Good morning and welcome to the District of Columbia Court of Appeals. I'm joined this morning by Associate Judge Roy McLeese and Associate Judge Josh Steele, and I am Chief Judge Blackburn Rigsby. We have two cases set for argument this morning, and the first is Sarah RAMEY versus FOXHALL Urology Chartered et al. Counsel, are you ready to proceed?
Yes, I am. Good morning, Your Honors. May it please the court, Tim Clinton on behalf of the appellant Sarah RAMEY. I'd like to reserve three minutes of my time for rebuttal. Despite the singular medical novelty of Ms. RAMEY's theory of causation in this case, the jury found that her claims were barred by the statute of limitations because she, a lay person, quote unquote, knew that this theory of causation was plausible more than 3 years before she filed lawsuit.
Counsel, can I jump in right away? There was a decision to bifurcate the trial, first to deal with whether the statute of limitations requirement was satisfied, and secondly, to, if it was, then go on to liability. And so I'm wondering what was necessary in any medical advice or expert medical testimony in the statute of limitations phase as opposed to the liability phase. So part of the issue here is her parents were both doctors.
Correct.
And the argument is that they provided her with advice as well as many other doctors that she saw. So what was different about medical advice she received from 2003 up until 2017 when Dr. Castellano and Dr. I think it was Dunnell examined her, when you say she for the first time had a full basis to proceed to trial?
What changed?
Or to file a claim, excuse me.
Yeah, what was interesting about the bifurcated trial is it created a sort of artificial situation, and particularly because the defense engaged in the strategy of waiving inquiry notice. They expressly decided to waive inquiry notice because of the issues that came up in the Daubert briefs. The defense's position was this theory of causation is totally novel. There's nothing across all of medical history that connects this kind of procedure to her injuries.
Before we get to the inquiry notice piece, which I agree is an interesting question, I'm wondering what is the level of medical expertise or advice that would have been required to trigger the statute of limitations? Is it the same qualifying expert level of experience that you would need in a liability phase, or is it a lesser?
So to trigger the statute of limitations, our position is the standard has always been reasonableness under the totality of the circumstances. It doesn't require Daubert level qualifications.
All right.
And so our position would be that under the correct standard, which is not the one the jury was instructed on, the issue would be, did you receive an opinion from a treating physician with qualifications that a reasonable person in your shoes would have found reliable, of plausible causation? And then the next question would be, in context, should this person have relied upon that advice?
And why would it have to be a treating physician? I mean, imagine hypothetically that a possible plaintiff is subject to an injury or subject to a medical procedure and then has adverse symptoms, and then, goes online and sees a bunch of, peer-reviewed medical journal articles that say, here's a common side effect of this kind of an injury if something goes wrong, and thinks subjectively, wow, that's a good explanation. Why would that not be enough? Why does it have to be something from a treating physician?
Well, the treating physician language comes from Brin and his progeny, so it is what's in this court's precedent.
What do you mean as a flat requirement?
What it says is what we don't expect parties to act until they receive this type of advice from a treating physician. And that's just what the precedents say. In theory, I can see a situation where it would be reasonable to rely on something other than that. For example, a consulting physician asked specifically about this theory of causation.
I didn't see treating physician in Brin. I don't read Brin to require specifically a treating physician.
Yeah, the word doesn't appear.
Oh, I stand corrected then.
It says
That's the
expert
case.
medical advice.
Yeah, it has to rely on the expertise of it. So I could certainly see a non-treating physician. I mean, in this case, for example, her Dauber qualified experts were not treating physicians.
Right. Can I ask you another question along the lines of Chief Judge Whackmary's question about what our framework is here? At times when you're talking about what it is you think your client would have to have plausibly known, you're referring to a specific theory of causation. And I'm wondering whether that's right or whether it isn't. And so let me just ask, again, imagine that a possible plaintiff undergoes a medical procedure and has very bad symptoms thereafter and goes and sees a bunch of doctors, and all the doctors say, I can't tell, I really, this is a mystery to me what went wrong, but one thing I can tell you to a reasonable degree of medical certainty is this was caused by that procedure and it wouldn't happen if the procedure was done well.
Yeah, I don't.
So I don't have a theory of causation other than that, I can't give you a mechanism, but I can tell you a conclusion about that the procedure caused the injury. Is that enough? It doesn't have to be a
I do
specific
think
theory
so.
of causation?
No, I don't. And I think the cases do talk about this. You don't need to know the specific mechanism, but you still would have to have a theory of plausible causation. And that was absent in this case.
Well, just to be clear, but the causation could literally be only, I am saying to a reasonable degree of medical certainty, I don't know how, but I'm willing to say that some defect in the procedure caused your current symptoms. That would be enough, even if that might not be a way to, might not be enough to prove your case at trial. It might or might not be, I guess, but that's sufficient theory of causation.
I think it could be. Well, I think more importantly, for purposes of statute of limitations, if one received that kind of advice in the context where a reasonable person would have relied upon that and saying, now I have a plausible claim and I should explore it further, then I think it would be reasonable to trigger the statute of limitations.
Yeah, that second piece of your test, which I don't really get from Bryn. So I'm wondering where it comes from. And let me give you a hypothetical. Let's say Ms. Ramey talks to 100 doctors, expert in the field, and 99 of them say there's no chance that this is related to that dilation procedure. And one of them says, actually, I'm quite confident it is. You would think that satisfies the Bryn test, that it is expert medical advice, that it's reasonably plausible that it's related to the medical procedure. Where are you deriving sort of the additional test of, and she should have relied upon it given the sort of counterweights? Because of course at trial, a jury could believe the one expert over the 99 who disagree. So, I mean, that would be enough to get you to a trial. It'd be enough for a verdict in support of you. But you're saying that wouldn't put you on, that wouldn't start the statute of limitations?
What Bryn says, if I recall, I don't have the specific quote, but the paraphrase, it says, at the end of the day, we're trying to figure out where exactly to draw this line. At the end of the day, it fundamentally comes down to reasonableness under the totality of the circumstances. So that hypothetical could have a million different permutations where the 99 doctors that said no were experts in their field, and the one who said yes was not an expert in the relevant field.
No, I'm suggesting that they are. They're all experts. But your answer is the statute of limitations does not get to run then, despite having evidence from which a jury could rule in your favor.
I think that in that scenario, if that doctor had relevant expertise under the Bryn standard, that would be a necessary requirement for the jury to consider the question, but it's not on its own, it's not sufficient. The jury would be able to, the jury could find it sufficient, but that's a question for the jury under the totality of the
Well,
circumstances.
Brent says that with some, and the court carefully noted that with some medical opinion that the perceived evidence of wrongdoing is a plausible cause of the illness, the plaintiff can be expected to promptly seek additional medical and legal advice to illuminate the causal issue. Which seems to suggest that as soon as there's some reason to know and to have a plausible or reasonably possible basis that the plaintiff is expected to act, they have enough to move forward to begin laying out their claim. It doesn't, I don't see it fitting the scenario here of waiting nearly 10 years.
Well, and that's what's interesting about this case is that she didn't wait 10 years. What Bryn talks about, there are two issues that can trigger a requirement to act. One is what triggers the duty to inquire further. and the other is what triggers the duty to file a lawsuit. They're both somewhat related. And the reason Bryn talks about that is that sometimes when you file a lawsuit, we expect that discovery will illuminate new causes that gets you from plausibility to a reliable claim. That was particularly important in Bryn, because the issue in Bryn was her diagnosis was well accepted within the community. Sick building syndrome was something that everybody knew, and the causal link was inherent in the diagnosis itself. Problem was the diagnosis was very difficult to make. So in Bryn, the missing piece of the puzzle were these air quality reports that she arguably could have received earlier than she did. In this case, Ms. Ramey went on a quest against the advice of her doctors to keep conducting painful and invasive tests within her own body. That's where the missing link came, 2017. Doctors kept telling her, I don't want to do this test. I don't think it's medically indicated. We're never going to know the answer to this, right? So in 2017, she got the medical test that made it plausible.
That was a test that I think had been previously done a number of times. So
Correct.
what was different about that test that made it plausible the fifth time, I think?
Yeah, so the evidence at trial was this test is one that is, the area of the body is very difficult to image. So it can take a long time. It's very nerve dense and nerve rich. It's very hard to image correctly. So they did it sort of generally looking for problems 4 times over. The fifth time, the difference was, this was Dr. Marvel, who in 2016, who's sort of the most qualified expert of all the people she spoke to, who affirmatively told her, Dr. Dunn didn't cause your injuries. He mentioned to her this concept of neuroma. She discussed this idea of neuroma. She said, well, how could we see if I have a neuroma? And he said, well, you could go in under twilight sedation, not just do the test, but you could palpate the area. The difference was they weren't just looking for the image. They were feeling for a problem. And even under twilight sedation, what Dr. Castellano said is you practically jumped off the table. So that was the moment. It was the similar test, a transvaginal ultrasound, but they conducted it in a different way because for the first time, they were thinking about this idea of a neuroma. And that's why they found it. That's what led to the discovery of this mass. That's what led to the later surgery that showed that it was scar tissue. And it was because she just kept insisting. She thought that the transvaginal ultrasound was the key.
So how does that, and I may have missed it, but I didn't see it in, the listing or the description of Dr. Dunnell's test or Dr. Castellano's test. There's some dispute about whether and if either Dr. Castellano or Dr. Dunnell linked this neuroma test to the test done in 2003, the urethral dilation as a cause of her injury.
It's interesting because the 2017 test, in fact, the date that the lawyer who filed the lawsuit, we came in after the lawsuit was filed, but the date that they used, that they filed within 3 years of, was the date that she first heard the term neuroma from Dr. Marble. I think it was like October 31st, and then October 30th, 3 years later is when she filed the claim. So the idea was once she heard the term neuroma, that triggered a duty to investigate, well, what's a neuroma? How could it be caused? Do I possibly have that? And she did. She followed up. She had Dr. Castellano's.
How was it linked
test.
to the 2003 injury and test done by Dr.?
Yeah, it's interesting because
Well, isn't that what the link that we need?
yeah, Dr. Dunn. So what's interesting is that the link was never actually connected until probably a week before expert reports were filed in the case. Dr. Dellin did believe when he came in surgically and found scar tissue, he said, I think Dunn caused your injury. But they still continued to believe, goes to your point about the mechanism of injury, they still believed that it was like a mechanical injury. What the experts ultimately came to was if there had been a mechanical injury, there would have been some sign of it. If there was like a puncture or something, it would have shown up in all these studies, and it didn't. What happened in those preceding 14 to 20 years was advances in science about these more subtle processes that the expert ultimately put in the Daubert report that are functionally undisputed now by the defendant's experts, which was inflammation at the terminal end plates of these nerves, which cause nerve problems. This sort of neuromuscular feedback that led to chronic tension in the muscles was caused a lot of this pelvic pain. And then this sort of, I think they call it cascades of systems that came from these sort of systemic failures that came. And all these 3 things happened concurrently and created these sort of subtle changes not the sort of puncture wound idea. So this theory wasn't actually understood or expressed by anybody until pretty much the date that the experts filed their report in this lawsuit.
And what's your response to, there is some expert medical advice, that this is a plausible cause of her injury, that the dilation was, and that comes from her parents. Her
Well,
parents are doctors. They say pretty clearly that they think this is what caused it. I would think if that's expert medical advice, that's going to trigger the statute of limitations. I don't know. Do you disagree with that?
I do. I think
You
there's-
disagree because on balance, there's more stuff that some other experts disagree?
I think there's two things. I think on the one hand, in context under the reasonableness under the circumstances test, I don't think it would be enough. And the reason is both of these doctors effectively told her, I'm not qualified to make this opinion. The reason they gave those opinions, the context they gave those opinions was to try and see if an expert would adopt it.
Well,
Every statement they relied on was a statement to a treating physician.
that sort of goes back to my initial question to you. Why, what was it about? They were both qualified doctors, and particularly with Dr. Larson, her mother, she had actually examined her. She had done some tests herself, and in addition to ordering tests. Why wasn't she qualified? And I guess adding on to that question, you keep framing the test as totality of the circumstances over 9 years, as opposed to how, I guess I read Bren a little more tightly framed, that when there's some basis in medicine based on medical doctors, medical advice, to provide a plausible basis for connecting the injury to the wrongdoing of the doctor, that is when the statute begins to run, which puts that point in time perhaps closer to the opinions of her parents, who were both doctors, and further away from the opinion in 2017 regarding the neuroma you described.
Yeah, I think there are 2 points to keep in mind. One is that when the DC Circuit first adopted the discovery rule in this context in 1971, and every case since then, the discovery rule's bedrock principle is reasonableness and fundamental fairness. And so if a doctor says, I'm not really qualified enough for you to rely on me, but this is what I think, you should go ask this other person, and the other person says no, it's fundamentally unfair to say they should run off and file a lawsuit. If, as happened in this case, that expert says, well, I guess it's theoretically possible, let's do a test, does a test that says, no, I don't think it's possible, you wouldn't say that that first statement of possibility requires you to go file a lawsuit, even though the doctor later withdrew or retracted that theory.
On that first point, just if we're talking about judgment as a matter of law, our review would be deferential. And if your point only is the parents' advice and information and conclusions is part of the picture, but it's on balance not a good enough part of the picture, that's a tough, that's a good argument to a jury, perhaps under a reasonableness under the totality of the circumstances test. But it's a little tougher for us to conclude as a matter of law that no reasonable jury could have taken a different view of that.
Yeah, I think that's a fair point. Our position would be that no reasonable juror, no reasonable person in RAMEY's shoes would have taken the advice of a person whose only qualification stated.
Understood, but just to interrupt again.
Yeah.
That's your argument to the jury. Your argument to us is that no reasonable fact finder could have thought that a reasonable.
That's our argument, right? That's our argument is that.
And can I ask you about this? This may be anticipating your second point. I don't mean to fully derail you from it, but in talking about Bren, in referring to the type of medical information that would be necessary to start the statute running, you have used the word expert a lot. And at least some of the time, maybe most of the time, Bren doesn't use that term. Just picking on one of them, picking one of the phrases, it says, since patients must rely on their doctors, a person can't reasonably expect it or required to act until that person has some medical advice. The word expert there, or the word expert is not present there, for example. And the next paragraph is sort of, and we're not saying it has to be the kind of expert opinion beyond a reasonable medical certainty that would be required to prove your claim at trial. So is it your view that Bren really does require that the medical advice be from an expert who is qualified, would be qualified to testify at trial on the issue?
No, our position is that there has to be some objective reason to sort of say that plaintiff in these shoes should have relied upon this person's expertise. The reason we talk about expertise, expert carries a term of art that implies Daubert. We didn't mean to do that. But from every case that we've looked at, if you look at Jones in 1971, the reason for this rule is it says the plaintiffs have to, quote, rely on those providing care, and it is only when he is acquainted with the problem that, I'm sorry, I'm reading the wrong section. They have to rely on the knowledge and skill of their doctors. And so in Hardy, which is another opinion, the nature of the physician-patient relationship requires the patient to rely on the knowledge and skill of the doctor. The same reason in Brin is it says patients have to rely on the expertise of their physicians. And then it goes down later and said some advice from a doctor. So the idea here, this goes to the case that Appellee cited in their 28K letter, which says that being a member of a subspecialty is not some talismanic, like you don't have to be a urogynecologist in order to give an opinion that would have triggered PATSCHAK, because we look at the substance of the qualifications, not the label. That same concept applies to the concept of being a doctor in the first instance. Would a reasonable person think that a pulmonologist, mother, whose role is to be your advocate with your treating physicians, is giving you the kind of advice that you should run off and file a lawsuit when those treating physicians who have expertise in the area are saying no? And I think Brin, Hardy, Jones, they all encompass this concept of reasonable people have to rely on some degree of qualifications and experts, not Daubert qualified, but something to say, we think you should run off and file a lawsuit. The converse of that would be, we don't want parties to run off and file lawsuits prematurely out of fear that they're going to lose their claims when they don't have
Right,
sufficient
but there,
objectively reasonable
in
basis.
between there is where we generally find ourselves, that there's enough to know that you have an injury and you have some medical advice telling you that the cause of it was this urethral dilation. You file a suit, you conduct discovery, you retain experts, and the suit moves forward. It sort of gets you across the 12B6 threshold when you have some medical advice to support a plausible or reasonably possible linkage. And the question is that the jury was charged with was determining whether that linkage and plausible, reasonably possible basis for it was established well before the time period within which Ms. Ramey filed.
Yeah, I think there's two important aspects to that analysis. And one is that it's important to bear in mind that the defense proved their case through effectively innuendo or out-of-court statements, asking the jury to draw from out-of-court statements conclusions that may or may not have come out if those people had testified. So one of the things that came out in the discussion in the Daubert context and in the party admissions brief was that if any of these doctors testified, Ms. Ramey's counsel would have been entitled to cross-examine them on what's the basis of this opinion that you gave, which would have provided context to the level of confidence with which a doctor spoke. The only witness who testified at trial.
Ms. Ramey could have called those witnesses too if she thought they supported her side of things. So I mean, each party made their tactical decision
That's true.
on that topic.
That's true, but the defendant had a burden. And so if any of those people had been called, I mean, the Ramey's position was every single statement, when you pull it out of context, which is what the jury got, was statements out of context. Every single statement was equivocal at best. He may have caused this.
What about the statements in some of the records that I recall? I think at least one of them by Ms. Ramey herself, saying that doctors had told her that the procedure was the cause of her injury.
Yeah, that I will admit that's the hardest statement. There's, I think, once or twice where she said to treating physicians,
Or not, some, I think, or
Yeah,
at least
she-
in one of them it's some, and
yeah, she says I think she said it once or twice. She
several, I
said,
think is one of them.
yeah, she said some of my doctors think that Dunn did X and some think he did Y. The problem with that is the jury had to speculate about whether those doctors had the kind of expertise that she should have relied upon. And again, not saying Daubert, but who is this that's talking? They had to speculate about that. When asked about it, she explained that here's who I was talking about. I was talking about the doctor who said, it's possible, let's do a test. And the next day said, I don't think that's what happened. She was talking about another doctor who, what they actually said, and it was supported by this doctor's medical records, said it's a theoretical possibility, but we'll never know the answer.
But the
And she was
jury
talking about her
also
parents.
had knowledge of what Dr. Larson thought it was. And that Dr. Larson, her mother, had done tests and ordered tests and done an examination. The jury had that information as well.
Yeah, and I think, Dr. Larson was a pulmonologist whose role in the case, the only evidence in the case was her role was to try and see if doctors would agree. And Ms. Ramey's testimony was, I didn't think it was reasonable to rely on her, but just as a layperson, I wouldn't have relied on a pulmonologist when the gynecologists are saying no. And she testified that her mom had a lot of wacky ideas. So she threw out this idea, and she also threw out the idea of zombie ants. So she felt like her mom was actually sometimes making it harder to get taken seriously by her doctors. So I think, that those statements by her make it a close case. In our view, they bring the case into equipoise. Equipoise is not enough for the defense to meet its burden. That's why we believe Ms. Ramey is entitled to judgment as a matter of law. But when you zoom out and look at if the appropriate standard had been applied, they certainly wouldn't have been enough in the context of this case with the wrong standard, with the defense stating that the standard in terms of mere possibility or subjective belief 50 times and exclusively, opening, closing, and rebuttal, and allowing the defense to do this bait and switch strategy where they waived inquiry notice to prevent the jury from hearing what would have been the centerpiece factual argument
Well,
of Ramey's case.
Sort of split those two things up because I think both, as the trial judge notes, that both counsel were a little loose on using plausibility, reasonably possible, and other words. But you started out, if you could take a few minutes now to address your point about the inquiry notice and what your concern about why that was early on in the trial removed from
Yeah.
consideration.
So in the Daubert briefs, defense made very strident assertions that were factually accurate and everybody agreed about the absence of any medical support for this cause.
Right, and I understand Ms. Ramey wanted to use that and there was a ruling that inquiry notice wasn't at issue here. If you could just.
Right. The court effectively said we would be allowed to bring those up if inquiry notice was at issue, but it was moved because they waived it. And the court said if they called any witnesses, we could ask those witnesses about the absence of medical records. So they didn't call any witnesses and they waived inquiry notice. Just atmospherically to the jury, being able to hear about Ms. Ramey's quest in the absence of medical evidence at all would provide, we believed, a lot of context to when a doctor says it's possible. The doctor is just acknowledging, well, this is a theoretical possibility, it's never been tested, provides context to understand.
You're not challenging in this appeal the correctness of the trial court's ruling that if the defense was not going to rely on inquiry notice, you would be precluded from introducing that evidence.
Right. We're not challenging that. What we're challenging is the prejudice of allowing them to bring up inquiry notice and rebuttal closing argument. And so this would have been the centerpiece of Ramey's defense. I think it would have been pretty powerful for them to hear about how she subjectively believed this with a religion degree from Bowdoin College.
What should the
doctor
trial
stood
judge
by it.
have done, in your view?
trial judge-
When it came up in closing argument?
At a minimum, immediately instructed the jury to, stricken that argument from the record at a minimum.
And
That's
that
one of the
was
things we asked for.
requested that by counsel
Yes.
at the time. And she did not do that. She did give an instruction. Why wasn't that curative?
The instruction made it worse. The argument that defense counsel made was sort of this series of events. Had she gone to a lawyer sooner, so there's no evidence of whether she did or didn't go to a lawyer. Had she gone to a lawyer sooner, that lawyer would have gone to a specific doctor, Dr. Iglesia. Dr. Iglesia, who the evidence showed had been approached in 2014, refused to do a transvaginal ultrasound because she said it wasn't merited. She had gone to Iglesia in 2007. She would have gotten the 2017 test results in 2007 that she ultimately got in 2017. As a result, she would have known she had a lawsuit. We wouldn't even be here. That was problematic for a number of reasons. One, it brought up inquiry notice. Not only should it have been stricken, we should have had an opportunity at least to address the counterfactual nature of this argument on sur rebuttal, which we requested and was denied. The second was, the whole argument was about what Ms. Ramey would have learned prior to filing a lawsuit. And the curative instruction that the trial court gave to the jury was, we're not talking about what would have happened. You're not to consider anything that might have happened after a lawsuit was filed.
I get that point, but your opponent argues that maybe this entire objection, or at least maybe more narrowly an objection to the problem in the instruction, wasn't really preserved, because rather than saying to the trial judge what you're saying to us right now, which is, you know, whatever else you're doing, trial judge, don't give that instruction, because that instruction is kind of a non sequitur. It doesn't address the problem that I've identified. The defense attorney doesn't say any, Ms. Ramey's attorney doesn't say any of that, and instead says that's all. And so there is a question about how well, at least that last point, was presented to the trial judge.
I think, Your Honor, you know, it's often difficult for trial counsel to make objections in the middle of someone's closing, but this argument went on for like 10 minutes. And trial counsel couldn't have, I think, more strenuously objected to the, you know, we're raising inquiry notice, shouldn't raise inquiry notice. They're talking about pre-trial, pre-filing, shouldn't talk about pre-filing, and the court ultimately made a ruling. It wasn't as if the court, which is the cases they talk about, sort of invited error, raise an objection, the court says, this is what I'm going to do, and counsel says, okay. That's not what happened. There was like a 10-minute discussion on this issue. The court rejected 3 different remedies that had been requested and ultimately had to accept what the trial court decided.
Can I ask, do you think by the time, let's say by 2010, Ms. Ramey could have filed a lawsuit that would have survived a motion to dismiss? Because I think she could have.
I don't. I don't.
A motion
think
to
she could.
dismiss? I
think
mean,
that-
usually the purpose of discovery is to give the parties an opportunity to develop the evidence necessary. You know, you can do further testing. So if she just came in and said, I had the surgery, I've been injured, I now suffer from something that is like related in that area. I have received medical advice. Let's say she explicitly relies on her parents, from doctors who believe this is the cause of the injury. That's more than you need to say on in a complaint. You know, you don't need to get into your evidence. You can just say, and I believe this caused my injuries.
That's fair. The plaintiff can say whatever they want in a pleading, and plaintiff could have said, this caused my injuries, and that would have potentially survived the motion to dismiss. I think that's fair. The problem was, and I think factually, I think the facts would bear this out. If she had filed a lawsuit at that time, 2010, 2011, 12, 13, 14, she wouldn't have won on summary judgment.
Right.
She wouldn't have been able to get an expert.
Yeah, that's kind of what I'm getting at. I'm curious one way of thinking about it is having a plausible claim in a complaint is basically enough to put you on inquiry notice. You know, you should go investigate things. Inquiry notice, not under the discovery rule. And so then it all comes down to, once she has sort of a plausible basis to file a complaint, did she act reasonably in developing the basis to that to get, you know, to expert medical advice, which, you know, is the top line of Brin. It says in the holding above any of the analysis, it refers to needing expert medical advice. And I wonder if the right way to think about it is in order to survive summary judgment, because if somebody doesn't have enough to survive summary judgment, then under inquiry notice, they could not have developed that evidence to survive summary judgment. And I don't really know why we would hold them to filing a suit that is doomed.
And that's
probably more for appellee's counsel, but just to give you a heads up.
I think that's correct. We don't want to require plaintiffs to file lawsuits that ultimately are going to be doomed. We also don't think we want to say you have to wait until you have enough to survive summary judgment. I wouldn't go that far. I think the standard would be, you have to have enough that a reasonable person in your shoes would believe that by the time you get to summary judgment, it's plausible that you'll survive. And so in the case of Brin, the missing evidence, again, was something that she could have gotten in discovery, right? You had a doctor that said, you might have sick building syndrome. I'd love to see the air quality reports. File a lawsuit. In her case, in Ms. Ramey's case, the doctors are saying, if there's any evidence that you could potentially ever prove this, it's in your body, and we haven't found it. And we're not going to do any more tests. So she went from doctor to doctor trying to get those tests. When she got something that said, this is now plausible, didn't even get to the point of summary judgment. I think that what she had in 2017, 18, 19, 20 would not have survived summary judgment. If you contrast this to, for example, the policy in Virginia requires you to have an expert opinion before you file a med mal lawsuit, right? And so DC doesn't have that same requirement, but we think as a matter of policy, it makes sense to say, you don't need to have that in your hand, but you have to have some reason to believe that you could get one once it's time to get that. And in Ms. Ramey's case, there's no way she could have gotten that prior to the 2017 transvaginal ultrasound.
Well, when could she have gotten it? She filed suit because the jury just found that she could have filed it before she did. How much more before she did?
Factually, she couldn't have filed it any more than she did. I mean, she
Maybe
filed
that's a
it.
question for me to ask. of
Yeah,
colleagues.
but from the jury's perspective, they were
She
told
filed it almost 3 years after, so she filed it close to
2020.
almost 3 years after.
She filed it within 3 years of the time she first heard the term neuroma from Dr. Marble. Neuroma led to Castellanos doing the test. Castellanos led to Dellin and the scar tissue. Those tests were what the expert ultimately relied on to come up with a completely medically novel theory about how this could have
Right.
happened.
Well, I know we've taken you well over time, but I did want to note that there were a number of other doctors, well, there were other, I don't remember the exact numbers, who found, there was a nodule that was detected. There were earlier tests that detected some type of mass.
Yeah.
From a nodule to a mass, other than just that 2017 test.
Yeah, that was the 2003 transvaginal ultrasound. So they had that, I think it was the first one saw a small nodule. They did it again and they couldn't find it. Actually, I'm sorry, they did it again and they said, we think maybe that's just thickening of the urethra from the UTI that preceded the procedure. And then the third time in the same year, within like 6 months, it wasn't there anymore. Then they did it again in 2008 under general anesthesia, specifically to look for that nodule, and they didn't find it. And so it was this quest from around 2013 through 2017. Ms. Ramey was just bereft of any answers. She took that picture from that first transvaginal ultrasound, this is her testimony trial, around to doctors and said, this nodule is the only evidence in my entire body that suggests this possible causal connection. The doctor said, maybe, but we don't see it there anymore. And so it wasn't until Castellanos palpated it that they were able to say it's still there and it's probably the source of all your pain.
Great, thank you. We reserve some time for a rebuttal.
Thank you.
Mr. Belcourt?
Chief Judge Blackburn, Bisbee, and may it please the court. In a trial that was carefully managed with a jury that was properly instructed, with instructions collegially crafted by both sides with the court, to which no objection was made, the jury made a finding on the evidence certainly within the ken of reasonable jurors. Stepping back for a moment before talking about the particular legal issues my colleague has raised, the legal trees, and looking at the majesty of the forest for a moment, what this case has been is a jury verdict supported by the trial judge most knowledgeable with the evidence that was fair and faithful to the law, the facts, and indeed common sense.
Mr. Belcourt, if I could jump in there. When we talk about the common sense of what the jury had to look at, they heard about Ms. Ramey's many different doctor visits and appointments and painful tests. You know, at what point do they, or should they look at and weigh the fact that, yes, she had arguably this opinion from her mother, who was a doctor, earlier on in the sequence of many tests, but then she had years of other tests that were non-conclusive or inconclusive. Why is it fair or correct or appropriate for the jury to have looked at and perhaps relied on just that one doctor, Dr.
Well, there,
Larson, when all these other litany of other doctors up to 2017 said, we don't see any connection.
well, there was a consistent contemporaneous theme in the documents. More than 3,400 pages, I believe, went to the jury. One witness testified, and that was Sarah Ramey herself. She read from contemporaneous documents, most of which she wrote.
She's not a
Brit-
doctor, though.
This is what she said, and this is what the jury heard. And of course, we come to the court with the power of the verdict. This is what she said. I'm going to start with 2008 and be very brief. The central problem is no mystery, she said, and this is at Appendix 739. It all began in 2003 when a urologist ripped my urethra and everything snowballed from there.
Right.
Now, that doesn't mention any doctors. I understand,
Right.
Judge.
There were, and so that, keep going. Maybe there was a doctor that you were gonna.
In 2009, she wrote, I've seen the East Coast best doctors. She mentioned 9 specialties, from urology to gynecology to urogynecology, all the rest. In 2013, she wrote, and this is at 385, several physicians believe Dr. Dunn perforated the rectum, vagina, and resulted in the bladder being tethered to the soft tissue of the left vaginal wall, in addition to sepsis. I don't dispute that, she said at 405 and 409. In 2014, she said, and this is critical because the precise mechanism of the injury, whether it be a neuroma or adhesions or inflammation, whatever is causing this poor woman's maladies, need not be established under Brin. For that sick building, there was no, according to the reported opinion, demonstration of which toxin caused which malady, which toxin caused fatigue, or any of the other ills that were alleged. So the precise mechanism of injury is not necessary, but this is what she said. All that has to do is be tied. There has to be some nexus to medical evidence, some medical evidence. Your honors are quite correct. It need not be specifically a treater physician or even an expert who would be prepared to testify. So there has to be some medical evidence supporting her belief. And so this is what she said in 2014 at 425. It's unclear what mistake Dr. Dunn made. Different doctors have suggested he may have ripped all the way through the vagina into the rectum and created a small fistula, or he may have nicked a nerve, or he may have missed the urethra altogether. And then finally, in March of 2016, which is outside the period, the jury properly found that she should have brought suit anytime before 3 years before August 30, 2019. August 30, 2016 was the drop dead date. In March of 2016, this is what this, by then a mature woman in her mid-30s who had a master's degree from Columbia University, this is what she wrote.
Counsel, I'm going to cut you off because you're just giving me a litany of things that she wrote. It's established that she firmly believes Dr. Dunn caused her injury. And if she had expert medical advice that were plausibly true, this discovery rule comes into play and the statute of limitations begins to run. Where is that expert medical advice?
It's in the reports that she gave the jury, and it need not, I'm
Can you point me to a
going to challenge
page?
the word expert, Your Honor, with all due respect.
Here's the introduction to Brin. We hold, contrary to the view of the trial court, that under the discovery rule, the statute of limitations did not begin to run in this case until Brin received expert medical advice. that defective air quality was a plausible cause of her injuries. So challenge it all you want, but it's all over the case, and it's also the underlying justification for the rule.
But there's also the key passage about some medical evidence, and I
Yeah.
believe Judge McLeese was correct in asking the question, insinuating that research by this patient into the literature of peer-reviewed journals, which she apparently did, would be sufficient under Brent.
I mean, that was his question. I don't know that was his
I'm not saying
assertion.
he's prepared to hold that, but
I don't think, so I agree that Bryn is certainly inconsistent. It does say some medical advice. It often says expert medical advice, and its top line holding is expert medical advice. So I think we need to figure out which one makes sense. And which one makes sense in terms of when somebody should be required to file a lawsuit, if they have some advice on which nobody could rely, because it's not any, like what, let me give you a hypothetical. Let's say I go to my doctor, my primary care physician, and I know you referenced this in your brief, but I don't see any cases cited, so maybe you have some. I go to my physician, and he says, I think you've got a problem with your arteries, but I'm not a cardiologist. Let me refer you to a cardiologist to check this out. And the problem is X, the thing that it ends up being. So he refers me to a specialist. I go to one specialist after another, and they say, for years, and they say, no, that's not the problem. I would think I've not received expert medical advice that that is the plausible cause, because the one person who gave me that advice, while a physician, was not expert in the field, and they said what you should do. I would think that would be enough to trigger inquiry notice to go talk to experts in the field. But if I then go talk to those experts and they say, no, there's nothing there, I'm not going to survive. My lawsuit's going to be out in a heartbeat. Why would we want that person to file a frivolous suit?
I have several responses to that, if I may. First, we can't ignore the word some medical evidence in the Bryn opinion.
I mean, I can say it was inartful when our top line was it needs to be expert medical evidence. You need to reconcile two things. We can't ignore expert either. I don't know why you want to ignore one and not the other. Which one makes more sense is my question.
I understand your question, and now I will try to answer it. First of all, the jury was entitled to credit the admissions of the only witness who testified. When she says she saw the best East Coast doctors. When she referred to her parents as top notch. Now, the argument that she makes in this court that her parents' views should be discounted because they were not within the same specialty was never made as a question of law below. It was argued as a matter of fact, which of course was her prerogative. The jury didn't buy it. But this is not a case. And the jurisprudence is well known in this court. Going back to Hawes versus Chul, Medlantic versus Hill, and Waneri versus Sandage. There is a procedure to follow. If you are challenging the qualifications and competence, the foundation for a physician, whether it be a treater or an expert, to render opinions. And that's the move on relevance grounds or on foundation grounds. That was not done. So we are left here with the jurisprudence of this court, which says that it can be any doctor who could testify. This is the Snyder case. Any doctor who is established to be knowledgeable, whether it's in the same expertise or not, can render opinion in that case on standard of care. Now I will turn to the two doctors who are most preeminent, and that is the
Before you get into the facts, let me just follow up a little bit on the topic Judge Deal was exploring with you about what you think the standard sensibly should be. Because Bryn does seem to at times focus on expertise, at times not refer to it. So there is a question about, what is the standard that makes sense here and what's the best interpretation of Bryn. But just to give you a hypothetical about the relationship between what the standard is and when it makes sense to initiate a lawsuit. Imagine that a possible plaintiff undergoes a medical procedure and ends up having bad symptoms thereafter and goes and sees, ends up having bad symptoms thereafter and thinks something went wrong and goes to an expert in the area. And the expert in the area says, I think one of three things happened. Either the doctor who performed the procedure was, incompetent in the following way, and that's causing your symptoms, or B, you had a pre-existing condition and that's causing your symptoms, or C, you were exposed to something environmentally that's causing your symptoms. And I think they're all equally likely. So I can't testify. I wouldn't be able at trial to testify to a reasonable degree of medical certainty that there was malpractice here. But I can tell you that's one of the explanations, and that's the best I can do.
That's
Is that something where you
precisely
think, is that something where you think there's a plausible case and you're required to bring your lawsuit and lose, or hope
You-
that in
you could-
discovery you get better? Or what's, I'm just trying to figure out the relationship between
that's
how
the-
much you need to know to initiate your suit and what your likelihood of success is based on that knowledge. So I'm just curious about your answer to my hypothetical.
precisely from Bryn. I will answer precisely from Bryn, which cited cases and also in its own text said it could be the causal link can be said to have been one among many causes or several causes. It doesn't have to be the sole cause. It could be one among several. One case said, and this is a case that Bryn quoted from New Jersey, said, as long as there's some reasonable medical support, inclusion within a differential diagnosis is enough. And what Your Honor has hypothesized is a differential diagnosis. It could be one, it could be two, it could be three. That's enough, according to Bryn endorsing the New Jersey court. In Maryland, the sister jurisdiction from which our common law derives, the case that Bryn cited was a case where carbonless paper was alleged to have caused cancer. The standard that the Maryland court accepted was could be. Medical information saying that this could be the cause.
That's definitely not our standard, you'd agree, because that just sounds like possibility. And
That
we
was-
agreed, we rejected that in Bryn.
Brent, no. Bryn endorsed that by saying this, our holding is consistent with, this is language right out of the opinion. Our holding is consistent with the holdings of our sister jurisdictions or other jurisdictions. Maryland, of course, is the close, and it said Maryland is the closest one. It even said that in the opinion.
Are you citing Helsinki? The Bryn's discussion of Helsinki, the District of Maryland case?
Yes,
As to causation, the court noted that the statute began to run when the plaintiff knew or should know that the injury was probably caused by the defendant.
yes. And if Your Honor reads further, Your Honor will see the words, it could be the cause.
Okay.
Well, Bryn does talk about a quantum of knowledge sufficient to trigger accrual of a cause of action as being somewhat can be imprecise. And it's up to the finder of fact to determine it. So what was the medical advice that was the sufficient basis here?
I will answer that. And Your Honor, Judge Deal, the passage I'm referring to is at pages 798 going on to 799
And that's saying that's the first time she got,
when she was convinced.
right, that was the first time she got testimony from a doctor that it could be a cause. And then the test it relates in the next paragraph is that, this is from Maryland, she had to know or should have known that the injury was probably caused by the defendant. That's the Maryland case that we're citing to in Britain.
That apparently was a constructive notice case. This is not. This is actual notice. We stand here and say she had actual notice sufficient to ring the bell. And then within that 3-year period, after doing whatever investigation she would have had 3 years. 3 years, and 3 years from when the bell rang to conduct pre-suit investigation. And then after suit, to conduct the discovery that Bryn contemplates and that my trial counsel argued. Now, what I would say to Judge Blackburn-Rigsby is this. 3 things. The parents at pages 322, 323, they wrote prescriptions. They ordered lab studies,
And
diagnostic studies, imaging,
the mother,
and actually examined the woman. Yes. Ms. Ramey called her parents top-notch doctors. They're ridiculed in this court, particularly the mother, But the record, what the jury heard is not that she was a doddering fool, but she was a licensed physician in her 60s who had opinions. And those opinions included this at page 412. This is Dr. Larson. Quote, she had an injury following a misguided urethral dilation, resulted in fistula, infection, burning pain, injury to pudendal nerve. Her father, Dr. RAMEY, quote, the most plausible explanation. How ironic he would use the term right out of the case. The most plausible explanation for her problem is that Dunn caused a fistula resulting in inflammation and other injury. This is at Joint Appendix 915 and 916. Now, Your Honor uses expert, but all that really is someone who has more knowledge than a jury and would be helpful. It doesn't have to be someone who's qualified, presented, and tendered and accepted. These are experts. The pulmonologist and an endocrinologist are experts. Their opinion, which the jury heard through the mouth of the party as admissions, to which there was no objection, I emphasize, either on hearsay or anything else. Those experts provided the sufficient nexus that would ring the bell starting the statute. Again, then what happens after that? She has 3 years to build, to investigate or perhaps build a case that would survive a 12b6. And then once she files, as Bryn contemplates, she has the opportunity to retain experts who then would take the quantum of medical knowledge to something less than reasonable certainty, but more than lay suspicion, to reasonable medical certainty that could earn a jury's consideration. It has to be done in stages. The quantum of knowledge increases at each stage. But we don't say that you, and the Colbert case versus Georgetown is illustrative of, we don't say in this jurisdiction that you have to know everything before the bell rings.
Can I ask, again, I'm just kind of probing on what makes sense as a rule. So let's say, just take an injury, let's take this injury in 2005, that somebody says, let's say her parents or a doctor says, you know, there's a 1 in 3 chance that it was caused by that dilation procedure. So under our cases, maybe that starts the statute of limitations. But we know the facts on the ground are that you could not show that to a reasonable degree of medical certainty absent some test that isn't developed until 10 years later. You're definitely not getting past summary judgment if you file now. There's no test for this thing and nobody's going to be able to tell you one thing or the other versus it. So my question is, I appreciate your answer is probably going to be yes, it starts running in 2005.
She loses. And she
Why does that
loses
make sense is my question.
Because you don't have to wait until you have a winner. That's not what our law says.
No, it's not wait until you could have a winner is what I'm saying. Where discovery could have conceivably spun out the facts necessary to survive summary judgment. My hypothetical is that's not going to happen because that test doesn't exist. And every doctor says that test doesn't exist. There's no way you're going to be able to do this under current medical technology. And then 10 years later, a test is developed and she gets the test and it says it's that. And so she files suit. Why would we want to encourage somebody in that scenario to file a doomed lawsuit?
Your hypothetical defines the circumstance out of the equation. I mean, you're defining it that the only way that.
Yeah, I'm trying to get an answer to my hypothetical.
Well, I'm going to answer it by saying you can't have a rule. We don't have a rule that says the bell only rings when you can prove something to a reasonable degree of medical certainty. No, that's not the law. The law is the bell rings when you have some causal nexus, some medical evidence that it could be reasonably possible or plausible. And then you go on from that to develop your case. And you may lose. For example,
I think the question is, or one way of looking at the question is, does the bell ring when you have some information that makes it plausible that, let's say, malpractice caused your injuries, but you also have undisputed information, all of the information available to you is there is no way you'll be able to prevail on that claim. because no matter, there's no discovery that's going to help you, your claim is doomed to fail. If you knew that to a certainty, that's, I think, the hypothetical. So you have, there's some plausible information, but every doctor tells you, no one's going to be able to testify. There's no test that will help you. Your claim is doomed to failure if you file it. It's true, it's a plausible cause, but we know you will fail.
So
Is that,
guess what?
does
You
the
do not
trigger-
have a claim. I mean, yes, Virginia, some people who are disaffected and unhappy and feel that they want to run to court will get thrown out of court because they don't have a claim. If there's absolutely no causal nexus, so that the bell never rings, and there never can be a causal nexus because the test hasn't been developed yet, then that person has no claim.
So your answer is that the statute runs and the claim will be lost, and it may be that later we will learn that there was a valid claim.
My real answer is the statute's irrelevant because there is no claim. Never was a claim. There's never been
Well,
nexus.
there wasn't a known claim. In fact, we might later learn there was a valid claim. It's just that we didn't know it was a valid.
Someday, and I mean.
Yeah, I want to just jump in here. I know we're battering you with questions, but
I welcome.
I just, I'm not so sure that I agree with the notion that when you know you may have a viable claim, it has to be linked to some tests that may or may not be developed in the future, because medical science is always evolving, and we're learning new things all the time. And I'm not so sure that under this case scenario, we sort of have the benefit of the almost 10 years of hindsight. I'm not so sure that that's the question that we're asked to look at right now. What we're asked to be looking at is whether there was a plausible or reasonably possible medical advice or medical knowledge that her injury was connected to the 2003 urethral dilation procedure. And I don't see any case law that says you have to know when you file a claim that would prevail on a 12B6, that you have to know at that moment you file the claim that it will prevail on summary judgment and possibly prevail to a degree of medical certainty at trial. And so I don't know if you finished the answer about the parents are they the only medical advice that she had in this 9-year scenario? Or was there other medical advice, expert medical testimony?
Her brother wrote an email citing.
Brother's not a doctor or not a medical doctor.
I understand.
That wasn't
I understand, but he
immediately
quoted
clear.
Dr. Goodman, who was at the Mayo Clinic.
Okay.
And, if your honor's going to say, but that's hearsay, well, it was not objected to and it probably would be admissible anyway. It's in the records that were jointly agreed to go to the jury. We can't retry this
So
case.
Dr. Goodman at the Mayo Clinic.
Yes,
and-
he said it was probably a pelvic, some kind of issue. I discussed it in the brief. The pages 14 through 18 in the brief really go through the
Right,
facts.
so what about the several medical doctors that Ms. RAMEY herself testifies to? I don't know if she,
Well, she didn't
name them.
call any doctors.
I know, but she says that they said that she had a connection. You referenced that a moment ago.
Right, she says.
That we can't count.
He says, my colleague says, it was never brought to the attention of the jury. It wasn't. His experts he mentioned today it could be any one of three things. It could have been Dunn's procedure or two other things.
No.
Again, that's a differential diagnosis.
No, I guess what I was asking is, was the jury allowed to credit Ms. RAMEY's reference to several doctors told her that this could be related to the 2023 procedure if we didn't know much more about?
They could have credited anything she said. She said multiple times during the course of the direct examination, which of course was most favorable to Dr. Dunn. This is what I'm going to quote now, because this is an actual knowledge case, subjective, not constructive or what a reasonable person could do. And the notion that my colleague brings into the case that there must be reasonable reliance on a medical evidence or a medical opinion, that's not in Brin, and it wasn't in the jury instructions, and he didn't object. And he didn't suggest it. at the time of the jury instructions, and I can read those quotes where he accepted and we embraced them. I mean, it was the most unequivocal waiver of an objection to jury instructions that one could see. So you're forced to deal now with plain error, and there wasn't, because these instructions were correct. But this is what she said. When going through this constellation of all the doctor's opinions that were quoted to the jury through her and her contemporaneous records, this is what I thought was going on. This is what I believed. That's at 324:26. This is my representation of what I believed. I'm stating what I believe at 371. It is accurate as to what I believed at 381. This is what I believe occurred at 409. Clearly she believed it, and clearly there was the nexus. She quoted, and I've read some of them, and others are in the brief, in 3,400 pages of documents. To be sure, there was other references in documents that she now relies on that could suggest, I don't know what it was. But that was for the jury to sort out. And it did sort it out. And it credited her. And he could have called, my colleague could have called other doctors to say, well, that's not really what I meant. Or she misinterpreted what I said. Or her mother is wrong. Her father is all wet. But he didn't. And so we're left with a record that's cold. But this is what the jury, who was very warm, heard.
Counsel, you're, I know, way over time, but I am interested in hearing your response to your opponent's argument about the closing argument and inquiry notice. First, I'd be interested in your trying to explain, because I confess I didn't fully understand the point in your brief, at least, about why that was not an inquiry notice argument.
Because all he was doing or trying to do was say what Bryn said was, once you have that nexus and you go to a court, or when you go to a lawyer, the lawyer.
What did Bryn say about going to a lawyer? That's not an inquiry notice point?
It's not, no.
Obviously, what did Bryn say about going to a lawyer?
Oh, it said that in justification of the lesser threshold on the quantum of knowledge that was necessary for the bell to ring, not reasonable certainty, which wouldn't get past the summary judgment motion. There's time to develop that through discovery after you've gone to a lawyer. And if the lawyer makes a determination to file a suit, it is not what she should have done. It is what she did. And once she does it, or should, which the law requires her to have done with the knowledge that she had, then all the fruits of our legal process are brought to bear. She can retain an expert to test an hypothesis. She could sign up an expert who may believe that there's a reasonable certainty of what she says is true. And getting back to your Honor's question on what if a claim, in my view, my interpretation, what if a claim is so frivolous that the bell never rings or she can never bring it? That's like, there may be people today who have cancer who believe that living near a windmill in Atlantic City caused that cancer. And perhaps they can find a doctor who would testify to that or be prepared to testify to that. But suppose there's nothing in the literature, just like cell phones causing cancer. Suppose there's nothing in the literature that supports it. The trial judge may well strike the expert, or may grant summary judgment in favor of the defendant, or if it goes to the jury may find for the defendant. So signing up somebody sufficient to have the bell ring, even if it's what used to be called junk science, is not a guarantee of victory. But it does, for the protection of the defendants of the world who have to defend against these claims, start the running of the statute so that there's that 3-year period to build a case before you file it and survive Rule 11. And then you survive Rule 12b-6. And then you survive Rule 56. And if you survive all that, you go to a jury and you may win.
You kind of shifted, at least there was a bit of a segue from trying to zero in on the exact argument here. I'm still a little puzzled about the argument the counsel made in closing was the reason you have a statute of limitations and the reason you go to a lawyer. Going to a lawyer as part of a pre-investigation, a pre-suit investigation an antecedent to a suit seems, it's quite different. The reason you file the reason you're required to file a lawsuit is because here are things that happen. But that's not what the argument is. The
Well,
argument is the reason, what she should have done is the clarification.
But that's not what it
is-
says. I understand what your honors are reading, and I understand your honors' interpretation of it. I fully could see how that could be interpreted that way, but it also could be interpreted my way, which is that once the statute runs and you go to a lawyer.
I don't understand about going to a lawyer. I mean, you mean
Because he-
file a suit, or do you mean go to a lawyer as part of a pre-suit investigation? Which do you mean?
No, and file the lawsuit.
That's just not what's said. So,
Well, but it doesn't say what your honor's interpreting it to be either, with all due respect.
no, what he says is here, if the reason you have a statute of limitations is if Ms. Ramey went to a lawyer, here are the things that would have happened. And, she would have learned things, she would have learned things that she only learned way later. The clear implication being because she didn't do those things.
All I could say, and it's repeating myself, and I have nothing more to say about it, is that wasn't me you're quoting. I don't know what trial counsel meant, but I'm reading the record, the cold record, just as you are. And my interpretation, consistent with what Bryn said, is that once you do file suit based upon the sufficient predicate, factual predicate that you are required to have, with the lawyer can then build the case, if you have a case, through discovery, to get you from reasonable possibility or plausibility to a reasonable degree of medical certainty. The lawyer does that through the discovery process, through retaining experts and consultation, all of which is part of our process for the protection not only of the plaintiff, but of the defense, because memories do fade.
So your point is you would read going to a lawyer meaning go to a lawyer and file a suit, and then the rest could have happened thereafter.
If the lawyer concurs consistent with his or her obligations under Rule 11, that there is a suit. There may not be a suit.
And can I ask you?
It may be as frivolous as, the day is long.
Got it. And what's your response to your opponent's argument that the instruction that the judge gave to the jury after an objection was raised to this was really off topic, because the instruction said, see if I want to make sure I'm oriented correctly. But it said to the jury, the issue is not what Ms. Ramey learned after she filed suit, or would have learned after she filed suit.
Right.
Not anything she may have learned after she filed the lawsuit. And
I may be wrong, but there was no exception taken, no objection to that. I understand.
I get that point, but do you?
And then
agree?
further, the instructions, with the global instructions that trump everything, if I can use that word, where whatever counsel says is not evidence, you decide on the evidence. And the jury is presumed to have followed those instructions.
I get all of those contextual points, but do you have any response to the point that substantively it's off topic? It doesn't respond
No,
to
I
the
have
time
nothing
frame.
further to say on that.
Thank you.
But counsel did say, before the instructions were read, we've reviewed more closely the court's proposed discovery rule instructions, which did not include reasonable reliance, by the way. And although we'd love to wax philosophical on this a little bit more, we've decided not to advocate for any changes. That's at 522. At 523, we do not necessarily need anything else to be stated. Parrot the language of Bryn, he said at 650. That's all we're asking for. All of that works for plaintiff. And then there was no objection at 697 to the instructions after they were determined. No objection, and that's Rule 51. If you don't object before the closings and the instructions, and you don't state the grounds for them, then it's waived. So then you get to the world of clear error, which we don't have here. So for these reasons, and for the reasons stated in our brief, the jury's verdict was soundly based on the evidence. I mean, I remind the court that for the appellant to win on the argument on the evidence, it must be that the only reasonable verdict here would have been for Ms. Ramey, and that's not the case.
Now, if we were to agree, I wanted to follow up on Judge McLeese's question. If we were to agree that counsel's comments during closing argument introduced this potential of inquiry notice, and as you said, there was no objection, but I think defense counsel, appellant's counsel.
There was no objection taken to the language the court used to cure it, which Judge McLeese read. If that wasn't adequate, the judge should have been given the opportunity to make it clear and adequate, and he didn't do that. And if Your Honor is suggesting it would be harmless, I'm going to say it would be harmless. It's overridden by the general instructions of what counsel says is not evidence. And it was a little bit of a pimple in the big scheme of this trial and all the evidence that the jury heard. The jury heard exactly what Bryn required. Actual knowledge based on reasonable possibility or plausible causation provided by medical evidence.
Speaking of raising points or not raising them, you've just now suggested that if the argument in closing was impermissible, it was harmless. And I was curious if that's a point you make in your brief.
No, because I don't believe it was erroneous, because I disagree with Your Honor's interpretation of what trial counsel said. So I never reached to the harmless error point.
So do you think, would you agree that the harmless error point isn't properly in front of us and we shouldn't consider it and we should address the issue solely on the arguments you made? And if you.
Well, I was responding to what I took to be an underlying assumption of Judge Blackburn-Wisby's question.
No. My point.
Oh, I'm going to say, well, of course, if Your Honor were to disagree, and that was an error for the judge to have made, then I think it is appropriate for taking into account this entire trial record and all the evidence that was before the jury and the other instructions that the jury received to view that as harmless.
I get that. My point was a procedural one, which is, do you think it's appropriate for us to consider that argument if you didn't brief it?
Yes.
And why?
Because it came up here. Because it came up here. I didn't bring it up. But it did come up that if it was wrong. And the natural response is then you look at the entire of the circumstances. I understand that arguments generally not made in a brief or it can be overlooked, but it would be wrong to overlook this one, is my point. Because it's such a small issue in the big picture of things, even if it was wrong, which I don't concede it was.
Thank you.
Thank you, Your Honor.
All right. Mr. Clinton, we'll give you a few minutes for rebuttal.
Thank you, Your Honors. I'll try and just keep it brief and focus on a few important points on the new trial issues, which included inquiry notice. The argument that was made was Ms. Ramey goes to a lawyer and, quote, does investigation, quote, so they investigated to do the ultrasound. And wait a second, the eureka moment isn't 2019, it's from 2007, or within the statute of limitations, she's got an answer and she's got a viable lawsuit. Now, this argument was made after defense counsel made their whole closing argument. Ramey's counsel got up and said, let's look at all the medical evidence, 3,200 pages and 90 different doctors, et cetera. They didn't have a viable lawsuit until 2017. He effectively sort of implicitly conceded, well, maybe she didn't have a viable lawsuit, but if she had done more, she would have. That was so prejudicial in what would have been at least a close case at best. The effect of that prejudice can't be understated.
Well, the trial judge's instruction at that point to the jury was the issue for the jury to decide is what Ms. Ramey knew of her injury, the cause of her injury, and of some evidence of wrongdoing by the defendants, and not anything she may have learned after she filed the lawsuit. Why is that instruction problematic? Doesn't that tell her in large part what Bryn tells her to do? What Bryn instructs that, you know, what did she know of the injury? What did she know of the causal connection and evidence of wrongdoing? That's what Bryn requires that she, we have to measure in order to determine when the statute of limitations began to run.
Right. Brin encompassed concepts of inquiry notice, which had been waived. And so the problem with the objection, which the court clearly rejected in that discussion, was that this invoked inquiry notice in the first place. So for the jury to not be confused, either to have the argument stricken or to give Ms. Ramey's counsel an opportunity to respond to it at least, the instruction had to very clearly say why this was an improper argument and to say, hey, we're focusing on this issue. Don't look at what may have happened after a lawsuit.
So the
Mr.
language of the instruction is not problematic. What's problematic is that it didn't go far enough to clarify the error.
It wasn't responsive to the problem. The problem was he invoked this concept of inquiry notice. It was counterfactual, and it was based upon a basically opinion testimony of counsel.
And just to be clear, was an alternative instruction, you said there were three options, I believe you said, given to the trial judge that she rejected in favor of this one?
Oh, I have it in my brief, Your Honor. I don't remember exactly the issues, but trial counsel, in the course of this very lengthy objection, asked that the argument be stricken, asked for an opportunity for sir rebuttal. And I think there was a third remedy. I just don't remember exactly what it was. Maybe it was a more specific.
Yeah, I don't
Curative
remember the
instruction.
third, I remember the
I'm
sir
sorry,
rebuttal
Your
and the other, I don't remember the third one you referenced.
I don't remember. But I think it's very important just to keep in context that this, at best, this was a very close case. This went to the very heart of Ms. Ramey's defense.
It was, just to interject, sorry, this, the
Yeah.
second remedy listed, or the third, was to instruct the jury that it was improper to say that a lawyer would have gotten the medical evidence from a doctor who previously refused to do this medical evidence, which I assume you mean
Yeah.
procedure.
Right.
All right.
Right. Another point that defense counsel raised was this argument of invited error, which was in the brief. Didn't really talk about waiver so much, but invited error. And I think we point out in our brief that this concept of reasonableness under the circumstances was presented in Ramey's pretrial written instructions. It was discussed and advocated a week before trial. It was discussed on the first day of trial when the trial court said, I'm rejecting the quote philosophical approach that the Brin case took, and instructed the parties to work on this other framework. Counsel brought it up again in an objection to opening statements, which the court didn't adopt, brought it up again right before opening statements and then during objections on opening statements, brought it up again during objection in Ramey's cross. And none of those times did the court indicate that the court was willing to reverse the decision made previously to reject this philosophical discussion. And then during the charging conference itself, the trial court again made clear that the trial court's view of the instruction was that the jury's job is to find a fact that, quote, triggers the running of statute of limitations, and that this concept of reasonableness was an extra step. So the court had very definitively made this ruling. Ramey's counsel very clearly advocated for that ruling. I do admit that trial counsel could have been more clear in making the objection during the charging conference itself. It certainly was an invited error, and it was raised in the post-trial briefs. There was another issue that Your Honor's brought up, a hypothetical that I had actually written out that I wanted to raise, the hypothetical. Your Honor asked about what happens if a doctor says there's three equally plausible claims. And so what if they said there's three equally plausible claims, but you could never prove that one of them is the case? If you think about the context from two ways, this discussion in Brin is we're looking at a subcategory of a broader test. The whole test is, when should a plaintiff reasonably know they have a plausible claim? And in a medical malpractice claim, that's negligence, causation, and damages. So you have to have some evidence of wrongdoing. You have to have, some kind of, you don't need to know all of the damages that you have. You have to have some kind of damages. And in the context of causation, has to be some medical advice of plausible causation. But these are all sort of sub questions to the ultimate question is, when do you believe you have a plausible claim? That's important because I think I misspoke a little bit when Your Honor asked that question about, well, what if you could get over a motion to dismiss in that scenario that Your Honor described? You could only do that if you violate Rule 11. Rule 11 requires you to know that you have a good faith basis and law of fact for your claims. If the doctor said you'll never be able to prove this, you can't go file a lawsuit based on that, right? And that was the scenario that Ms. Ramey was faced with. It's hypothetically, theoretically possible, but we'll never be able to prove it. You should stop looking, take psychiatric meds. That's what she was told for 14 years. So I want to just briefly focus then on the sufficiency of the evidence point, because counsel raised, I think, three things and three pieces of evidence that counsel said was sufficient to justify the jury's verdict in the case. The one that he talked about was Dr. Goodman, Mayo Clinic, the statement of the brother that was ultimately admitted. That statement was the brother, who's like a professor of comparative literature or religion or something, said, Dad said he suspects that Dr. Dunn may have caused this injury, and Dr. Goodman believes that suspicion is feasible. I mean, that's so attenuated to get to the, as an out-of-court statement to say, what feasible, does that mean possible or reasonably plausible? It could mean either one. It's equipoise. And what's feasible? The theory of causation or the suspicion of the theory of causation, right? It's a very equivocal statement. The next piece he relied upon, which you referenced, I think 3 times, was the statement that Ms. Ramey said, I saw the East Coast best rheumatologists and other experts. The full quote of that statement was, I saw these experts, they tested and scanned for urethral diverticulum, parasites, everything, and found nothing. 4 transvaginal ultrasounds, multiple MRIs, CAT scans, and a PET scan were done. Nothing was found, except on 1 transvaginal sonogram. There was a small mass detected near where the bladder and the urethral meet, but they looked for it again and never found it. My doctors had no idea what was going on and finally recommended I try antidepressants and anti-anxiety drugs because I was so upset. Counsel cited that email 4 times in the argument. The other piece that he relied upon that said justified the claim was the mom and dad's opinion. And he raised something that I had forgot to mention, which is both of their opinion of the causal connection was tied to this concept of a fistula. And the dad's statement that they like to quote was really interesting on this point, because what he said was, in that full statement, I don't have the quote, we cited in our brief, was that we're trying to figure this out. The most plausible explanation is, a fistula, but she's undergone an extraordinary workup and there was no sign of a fistula. I mean, the most plausible in that context doesn't mean plausible. It just means the most plausible of a number of implausible possibilities. And again, this was in the context of a statement to an expert trying to get their opinion. I think those are the main points that I wanted to address.
So, what do we make of the instructions to the jury, which told them what they could consider, which were not challenged and were, I think, agreed on by both counsel? The fact that the jury reached this verdict with the only witness that defense or appellants presented to the jury. On what basis would we hold, as we would have to do at this juncture, that the jury only could have found for Ms. Ramey based on the whole nearly 3,500 pages of medical testimony and evidence here?
So on the issue of judgment as a matter of law, again, you've got 3,200 pages of medical evidence, et cetera, the vast weight of which supported Ramey, but it became irrelevant under the trial court's instructions. So then what the court is left with are out-of-court statements where, I mean, it's an interesting post-trial motion because it's more like summary judgment. The court is kind of relying upon how to interpret the written word on a page bereft of any context. The only context the jury heard was Ms. Ramey saying, whatever it was they said, they were saying it's no more than a hypothetical possibility, and they were doing it in response to a lay person saying, please believe that this is true. And so then the court's job.
Well, that's because that's the only witness that was.
The only witness
presented
that
to
the
them.
defense called in an attempt to meet their burden was Ms. Ramey herself, and they relied on these out-of-court statements. There was nothing in the medical record that would meet the trial court's test. The trial court did invoke this concept of expertise. The trial court, in the sentence before saying, or a couple sentences before saying you must rely on medical advice, says patients are required to rely upon the expertise of their doctors. And so this concept of some level of expertise was invoked. So if you parse those, I'd never like to be in the position of saying parse the evidence finally, but if you're parsing the evidence, none of it ever met the test. So what the jury was left with was a sort of mountain of insufficient evidence, and taken together is still insufficient. Doctors might have said, may have caused. That's not reasonably possible or plausible. Doctor said possible, which is not enough. Dovetailing into why, if the court does disagree with us that a motion for judgment is appropriate, and even if the court were to accept the arguments that the jury instruction was invited error, what was left was, and what's very clear from Bryn spends 7 pages talking about where do we draw this line between mere possibility and plausibility or reasonable possibility. Trial court allowed defense counsel at least 50 times in opening, closing, and rebuttal argument over at least 3 objections to state that what mattered was subjective knowledge. What matters was what Ms. Ramey believed. What matters was what she took away. What matters was her belief. And phrased in terms of potential, possibility, or suspicion, none of which would ever have been enough. If that was the issue, there never would have been a trial. And so the jury heard that over and over and over in opening, heard Ramey's counsel object to it, heard the court overrule those objections, and then every single question posed to Ms. Ramey was phrased in terms of potential, suspicion, or possibility. Didn't the doctor tell you it was possible? Didn't the doctor tell you it was a potential? So by the time there was the charging conference, trial counsel said, Your Honor, we got to make sure that we, at a minimum, if you're going to work within this framework, get this line right. There is a substantive
Are we
distinction.
still on my answer to my question about the burden of proof that and the standard of review that we have with respect to the,
On the motion for judgment?
yes,
Okay.
briefly. 'cause
Yeah,
we're
jumping
way
back
out
to
of
that,
time.
again, some of the principles that come into play are here are that it's not enough to disbelieve the only witness that talks about something. It's not enough to say that the jury could base its opinion on speculation or, they can't go beyond the record that exists to sort of draw impermissible inferences that require speculation. And so what you're left with is effectively a written record disputed by the only testifying witness that is at best, and I think construed generously, equivocal. And so even if all the context doesn't matter, even if it's a one-way trigger, even if all you have to find is a single statement by a doctor, the trial court's instructions did encompass this concept of expertise. And again, we don't think it was a very high bar, but that concept of expertise was required. Defendant could have introduced more evidence about mom's qualifications. Being a top-notch pulmonologist is not a reason for someone to, rely on their advice. In fact, Ms. Ramey was asked about that, and she said, my mom's a pulmonologist. Why would I rely on her for advice about my vagina? My mom's examination was, she looked at my vagina.
I think you need to get to the final conclusion.
Okay,
And we've been very generous with time for both.
Thank you, Your Honor. No, I have no further comments. Thank you.
Thank you. We thank both counsel for your arguments and your briefs, and the matter is taken under advisement. All right, our second case for argument this morning is Michael PATSCHAK versus United States. All right, Mr. Lipper, are you ready to proceed?
I am. I would like to reserve 4 minutes for rebuttal.
All right, thank you.
Thank you, Madam Chief Judge, and may it please the court. My name is Greg Lipper. I represent the appellant, Michael PATSCHAK. Before we go into the details on the sufficiency analysis, I want to get back to first principles or so about just the robbery statute generally and what the DC Council has indicated about the seriousness of that statute. Robbery is one of the most serious felonies in the DC Criminal Code. It has a statutory minimum sentence of 2 years, a maximum sentence of 15 years, and it is one, like kidnapping and some of the other statutes the courts looked at recently, is one of the handful of crimes that can be a predicate for felony murder, murder conviction without intent to kill. And so the elements of the offense and the outer limits of those elements have to be considered in light of the overall seriousness of the statute, which is.
I mean, we've already interpreted the statute to cover things like pickpocketing and purse snatching, right?
Yes.
I mean, that takes a little bit of the heft out of your opening. Those don't strike me as the most serious offenses in the world. And, you know, I think your client got 15 days in jail. So we've at least softened the punch of the robbery statute by saying, there can be these sort of more trivial things that you wouldn't generally think of as a robbery.
So let me actually just get at something very briefly you mentioned, which is the 15 days in jail. 15 days in jail is actually for the misdemeanor assaults. The trial court fully suspended the 2-year minimum sentence for robbery, deeming the robbery, quote, marginal. And that's marginal under taking into account all of the court's existing case law. And I think that's because here we're not talking about a pickpocket, which is, I think, agree already approaching the outer limits of the statute. We're talking about something where the government had to go to the jury and say, no, I understand we don't have a pickpocket situation here. You know, this is something else. It may seem crazy that this is a thing. This is, essentially pickpocketing the body-worn camera off the ground, not off the person. And so we are, if you think about the pickpocket as sort of a, the sudden or stealthy seizure or snatching, which is, I think, the most sort of marginal example of robbery that the court's existing cases
Well,
have found.
take the pickpocket where the wallet is on the table nearby. You know, somebody sets their wallet there, continues, reading the paper, and somebody runs by and grabs it. That would be a robbery, right?
That might well be a robbery, although I think if it's that close, perhaps. But again, I think even then you're, at least in cases presenting something along those lines, you're dealing with stealth. So the Spencer case, which is the, I think, 1940 case about the guy in the hotel, lured to the hotel room, and lured into bed. There you have the wallet having been snatched unbeknownst to him while he was otherwise occupied. So there, at least, we're dealing with.
And why is that worse than if he had been watching? You make it sound like that would be it'd be a less serious offense if it had been an observed taking of the wallet. Why is that less serious? It strikes me might be more serious, in that it's more likely that there'd be an altercation relating to it if somebody was perceiving the taking from immediate actual possession. So,
Well, I think there's two issues. First of all, it was still extremely close in proximity in terms of, within the hotel room, just to the side of the bed. But I think the broader point is the statutory hook is at least closer there, because you're dealing with a stealthy snatching, right? And so you're dealing with a situation in which.
right, but the other statutory term is sudden.
I'm
Right.
sorry?
The other statutory term is sudden.
Sudden, right. But in looking at this, I guess what I'm saying is there hasn't been a situation in which the property is not on the person himself and it's taken in full view of the person, but the person is walking away and not making any efforts to return to the property. And unlike all of the other sort of cases, and you have no active or attempted physical assault and no concrete threat of violence. In other words, you have, in this case, and this
Sorry, why
is,
do you have no concrete threat of violence here? I thought that there had been prior assaultive activity and then there was subsequent assaultive activity. So you mean at the exact moment of the taking, or do you mean more broadly during the encounter as it might relate to how an officer or someone would respond to the taking of the object?
I mean, at the time of the taking, the Officer Todd, after he testified, he had been shoved from behind. And then the evidence shows that Officer Todd punched PATSCHAK in the face and then did his tactical takedown, brought him to the ground, and then turned around and walked away, literally turned his back to PATSCHAK and walk away. So at the time.
Can I stop you there? It's not how I recall the video. Granted, I don't have it in front of me. I recall his testimony being that he was walking away. The video, it looks to me like the officer wants another go at PATSCHAK and needs to be restrained by an officer. He's kind of being held back while PATSCHAK picks up this camera, and he says he sees him pick it up. So he says in his testimony, he's looking over his shoulder. It looks to me like he's looking right at him. So why couldn't a jury say, well, PATSCHAK is watching him. He would have, what's the evidence that it says, well, despite him saying that he was walking away because he was afraid of it, of a mob surrounding him, you actually see the testimony, and it looks like you would have gone back and gotten that camera if PATSCHAK didn't grab it and if you hadn't been pulled away by a friend.
So let me make, I guess, 2 points. First of all, I think the video of that video you're referring to, I believe, is Government's Exhibit 3. That is probably the least clear of the videos because it's shot from above. So we don't have that sort of ground level frame by frame kind of we don't have the ability to sort of parse it at the ground level frame by frame that we did in the case of the other exhibits that are before you. I think more broadly, what we see in that scene is chaos. I think it is quite, there's a lot of people kind of milling about, running around and whatnot. And I think the chaos is what I think informs whether Officer Todd reasonably could have gotten the camera, and thus whether the camera
Could have gotten the
reasonably
camera.
Sort of reasonably could have returned to retrieve the camera. In other words, whether it was in his immediate actual possession ultimately turns on what was it such that he if he had not been deterred by violence, whether he could have reasonably retrieved the property. Here we have no, at least, and again, I recognize the overhead video is a little chaotic. I do think it is significant that unlike with the other videos, you didn't have really any dispute. There was no one, even the government wasn't saying, well, Officer Todd's mistaken about what he was doing. There wasn't really anyone saying, no, don't believe Officer Todd, believe the overhead video. But I think ultimately the question is, was this camera sort of available to Officer Todd in a way such that PATSCHAK taking it off the ground is a reasonable proxy for, an assault on a simultaneous assault and theft of a person?
Can I ask you, do you think there's I would think ordinarily the jury could have a common sense inference that police officers wouldn't willingly just let civilians wander off with their police equipment. Do you think that's a fair common sense inference?
I think that cuts in our favor because I think that
maybe so, but I'm just asking first if you think it's a fair inference that the reasonable fact finder could draw.
I don't know about wouldn't. I would say I think it's they're not. It's something they're not going to readily let go of, or they're not going to readily let it go away. I think is reasonable to conclude, and I think that reinforces the point that if he could have, if it was within his immediate actual possession, and he could have gotten it, he would have. And so the fact
but I thought the government's theory, and supported at least arguably to a degree by Officer PATSCHAK's testimony, is that he acted the way he did in moving away from where the camera was because he was concerned about the risks that were posed by what you're describing as a chaotic environment that it involved prior assaultive activity and subsequent assaultive activity.
Well,
obviously
the subsequent assaultive activity was not obviously reasonably available to him at the time, but I think that is the government's theory, and that was Officer Todd. He said it was a little vague. He said basically, the main thing he said was that there was a bunch of people gathered all supporting the same cause. I think here's what he didn't say. He didn't say, I feared that PATSCHAK was continued to be a threat to me. And I think for good reason, because he had, in response to at most a push, he had sort of quite swiftly, he punched him in the face, he took him down, he completed his tactical takedown. PATSCHAK at that point, it wasn't like PATSCHAK went back at him, right? PATSCHAK was standing there. Officer Todd felt, the issue,
Does it matter? You're framing this as though the relevant question would only be to what extent Officer PATSCHAK either testified or
Officer
Todd, excuse me, could testified or could be inferred to have feared the risks of trying to prevent the taking of the camera. You're focused solely on Mr. PATSCHAK. Is that the right focus, or is it also part of the relevant focus, the totality of the circumstances? So again, if let's say Officer Todd had expressly said, well, at that moment, I wasn't very afraid of Mr. PATSCHAK individually. And if he'd been the only person standing there, I might have gone and retrieved my camera. But, you know, this was a chaotic environment. There were lots of other things going on, and I really didn't want to get into the middle of it without my camera. So I walked backwards. He didn't say anything like that, I understand. But if
Right.
he'd said that, would the risks posed by people other than Mr. PATSCHAK have been a legitimate part of what you're talking about as kind of the inquiry, as what you're suggesting is a relevant circumstance for whether something's in immediate actual possession?
So I think there's, I'm not sure you meant to have two parts to your question, but I perceive two parts to your question. One is sort of PATSCHAK versus a third party. And then the second part I perceive is sort of when we say a risk, what do we mean? There is a case, I believe it's the Leak case, in which it's somewhat equivocal because the court first held that, so the Leak is a case, I believe the bike theft case, in which one guy is wrestling with the bike owner. The one guy tells the defendant, go take his bike. The defendant then takes his bike while the other guy is wrestling the bike owner. The court first held that a reasonable jury could conclude that they were working in concert. The court then went on to say, even if they weren't, this would suffice. I think that second part is dicta, but even if it's not, and this goes now to the question of risk, there you had an active assault and an active restraint. And I think when you get more inchoate, when you're talking about here, Officer Todd saying, well, the scene was chaotic, that is where, and it's kind of why I brought up at the very beginning, the seriousness of the robbery law and how we're already at the very outer margins of it, allowing it based on sort of, inchoate testimony about chaos, I think is, would make the robberies far too marginal, number one, but also I think would then get these very weird anomalies where, for instance, if I'm in, I drop my wallet and I'm in Georgetown, I'm like, well, okay, I know this neighborhood, I can go get my wallet. So you have thefts in Georgetown, where if I'm in Trenton Park, I was like, well, Trenton Parks, I know that is a rough neighborhood.
To that point, though, we have language in the Rouse case, I think it is, where we say that if it's within the victim's immediate actual possession, and if the victim is not deterred by violence, I think this gets to your point, or fear, such that he would have retained it. And here, I thought we had some indication, maybe it's just argument, but I thought it was testimony of Officer Todd saying that he backed away because he was uneasy, he was in fear about what was happening. Doesn't that bring us within the framework of what Rouse is talking about?
I don't think entirely for this reason, because in Rouse and in all of the other cases, and ultimately, as the court knows, the court has, the court's sort of precedent on precedent ultimately says that we look not just at the statements in isolation, but we look at the statements as applied to the facts. And in all of those other cases, you had either an active or ongoing physical assault or restraint, or you had a very concrete, you had a concrete threat like, if you go get that, I'm going to shoot you, or something to that effect.
Well, Spencer isn't that, of course, Spencer, but
Or-
there you have stealth.
Or stealth.
Why does stealth make a difference?
Well, I think stealth makes difference just because there's an explicit carve out for stealth because
And there's an explicit carve out for sudden seizures.
There are, but now, but we're still dealing with the point of immediate I guess we're dealing with the immediate actual possession. And I think
I understand that. I'm just trying to figure out why you think the concept of immediate actual possession operates differently for stealthy seizures as opposed to from non-stealthy but sudden seizures.
well, I guess let me say two things. I think we don't know necessarily the outer limits of stealth because Spencer may be the outermost limit, at least of the existing cases, the outermost limit. And even that was sort of like right next to him, in his hotel room, right? Most of the stealth cases are pickpockets, right? Where it's actually coming from the person. So we don't have a situation, where you have a stealthy seizure, far away. But I think the reason it sort of matters, that distinction matters here, is because when there isn't stealth, then we can sort of, from the perspective of, we know here that Officer Todd did not actually, even though he saw what was going on, did not try to retrieve the camera. And so then the question is that because he couldn't reasonably have retrieved the camera, or is it because there was, you know, some sort of assault or threat that was stopping him from retrieving the camera, as opposed to sort of, you know, a more kind of general chaos or whatnot? And in my view, and if you look at like the fact patterns of the cases outside the context of stealth, every time, you know, even when you're talking about sort of the wingspan or the number of feet, that is positing that, yes, there was force or violence, actual physical force or an explicit threat of violence that is what was preventing the person from getting to their property.
And how's that in the pickpocket cases? The force is just the
In
removal from the actual person.
the
rather than
pickpocket
from-
cases, there's the force is you're physically taking the object from the person. And that is, I mean, that is an actual assault on the person.
Right. So if I'm sitting at a restaurant and I have my wallet out, I guess, with getting my credit card or something like that, and someone, you know, I'm not touching it, but it's 6 inches away from me, and somebody grabs it and runs, there's no force directed to me personally. Would you say that is or is not a robbery? It's not stealthy. It's done right. I mean, I see it happen. It's somebody. It's a
Right.
catch and grab.
But I would say it's so, you know, it's right in front of you, to the point that I think I'm actually actually, let me say this. I'm not sure one way or another. I think it would go further than the non-stealth cases have. I think the argument would be it is so kind of close, right, you know, so close to your body, you know, within, you know, right next to your soup, that you're gonna like put a spoon down and eat, that it's, you know,
Can I just maybe try to put it in the terms of the statutory language?
Yes.
Which is, the question is whether or not it was procured by sudden or stealthy seizure. And if the suddenness and stealthiness of it is irrelevant to whether or not they acquired it, I'm not sure I would say it was procured by sudden and stealthy seizure. It was, he could have shouted at the rooftops, now I'm going to take this camera. I mean, he's doing it in full view of somebody. Whether he moved quickly or slowly wasn't relevant to that. Is that your argument, that just under the statutory language, this is not something that was acquired by stealth because it was irrelevant to the acquisition of it?
No, I'm sorry. So what I'm saying, so here I think we're talking about, here would be under the, I guess, the sudden theory rather than the stealthy.
Right.
Stealthy.
Well, so I'm saying that the suddenness is irrelevant to it. He could have moved slowly, and it wouldn't have been relevant on the facts of the ground. If PATSCHAK had, you know, kind of sauntered over to this camera, the officer's leaving anyway. It was going to be there.
Well, I think this is, I guess the point I'm trying to make, and I think what this question leads me to think about is, ultimately, the question of immediate actual possession is, I think what the court has said in one case, it's an elastic question, right? So it's not a matter of just like, all right, I get your yardstick out. If it's, you know, less than 5 yards, it's thumbs up. If it's more than 5 yards, it's thumbs down. It's an elastic quality. Sometimes it's a lot, sometimes it's, and so now we're looking at the circumstances that are going on. And I think what's relevant here is that Officer Todd was walking away, was already walking away, so much so that he, or you know, certainly testified that, saw PATSCHAK pick it off the ground, but made no effort to try to stop him, and made no effort more generally to try to retrieve his camera, and sort of was walking away from his camera. And in that situation, I don't see how it could be said to be in his immediate actual possession under the circumstances.
I have two reactions. One, I kind of want to put a point on that, which might be what is in your immediate actual control in an isolated environment, like a wallet that's 10 feet away from me in a motel room, might not be in my immediate actual control in a crowded protest. So if I put my wallet down on a park bench and walk 10 feet away, same distance as the hotel room, but definitely in my immediate actual control in the first one, almost certainly not in the second.
That's correct, and that's a more elegant way of answering Judge McLeese's question than I chose.
I forgot what my second point was.
But I think just to pick up on that, I think
The second point was, one problem I have with your position is, defense counsel never argues retreat before the jury. At no point, there is this evidence, but at no point does he say, hey, jury, and this is why the video evidence suggests to me, you could watch Exhibit 3, you were right on the exhibit, and you could see he's not retreating. He's going at him, and he's being held back. And you don't have defense counsel saying, well, jury, that's chaos, and, don't believe your lying lies. The officer says he's retreating. The officer's just not retreating. So why couldn't they? So if he were retreating, I think that's a pretty powerful argument to, even if he could have chosen not to retreat and recover it, retreat is kind of an abandonment, and you don't rob somebody who's retreating from their property. That I get. I don't get why the jury had to conclude that he was retreating at that time.
So let me make 2 points. In terms of why trial counsel didn't raise it, I think, and this goes back, the government on appeal, we've been focusing here on appeal on just the sort of the secondary theory, the sudden or stealthy seizure snatching, from the curb. The government's main theory at trial was that PATSCHAK intentionally reached, grabbed, turned the camera, twisted the camera and removed it to steal it during the tussle. And the government has effectively conceded on appeal that there was insufficient evidence to support what was the government's main theory at trial. So I think in terms of why it didn't get as much airing by defense counsel, I think because the government's main argument was not that. The government's main argument was, somehow in 3/100ths of a second, PATSCHAK. And so I think that's the first explanation. But the second explanation is, and I think if you were expecting someone to take issue with Officer Todd's testimony that he was retreating with his back to PATSCHAK, that would have actually come from the government, because I think the government would have found that testimony less favorable. The government didn't try to say, hey, I know what Officer Todd said, but he's got a lot on his mind, and look at the video. So I think that is the omission that I think is actually more telling. But the final point is, even if it was his own colleagues who were holding him back, I don't see how you could charge that to PATSCHAK, or even if you sort of define the universe of protesters, even if you were to charge him, ultimately, there, and because we don't know, there may have been many reasons why those officers would not have, wanted Officer Todd to wade through a crowd of people. But ultimately, I think that takes me back to, we have kind of a chaotic scene, and that chaotic scene sort of reinforces why it wasn't in his immediate actual possession, in the same way that, as to pick up what Judge Steele said, if my wallet's on my nightstand 5 feet away versus if my wallet's 5 feet away on like Times Square on New Year's Eve. In one case, it's in my immediate actual possession. In another case, it's not. But ultimately, it's not force or, it's not a threat or force that's keeping me from it. In the second case, it's just the layout and chaos of the scene. So I think ultimately, even taking Judge Steele's point that, we do have at least a higher degree of marginality in the robbery statute than we might in, say, the kidnapping statute or the murder statute. Here, we are talking about a layer further removed from what we found in the cases. And it was a layer so further removed that everyone agreed this was a marginal robbery worthy of no jail time, in which the government itself, albeit inadvertently, asked for a sentence on robbery 22 months below the statutory minimum. I mean, that's how sort of, and that, all of that sounds in theft with maximum sentence of.
Can I, on
Yes.
the theft point, and actually on the robbery / should it be theft point, can you just talk very briefly, and we've gone way over your time with our questions, I realize that, but on the intent piece,
Yes.
particularly with respect to Mr. PATSCHAK, testifying that he sort of scooped up a whole pile of stuff that included the officer's camera and didn't realize it wasn't his immediately, but he puts it in his backpack, realizing that it's not his.
So we are not challenging that part of the verdict on appeal. So I think, and I think this the intent argument we were making was with respect to the government's first theory at trial that I think the government's now not relying on an appeal. So I think there is insufficient evidence to conclude that PATSCHAK intentionally tried to remove the camera from Officer Todd's person when they were up close.
No, I'm talking
Right.
about
The later one we're not challenging. We agree that that may not have been our interpretation of the facts, but we agree in that situation a reasonable jury could have concluded he had the intent.
Did you want to, I don't know if there are any other questions. Did you want to reserve the rest of your time for rebuttal?
I will take as much rebuttal time as much of my 4 minutes as you will give me on rebuttal. Thank you.
Thank you.
May it please the court, Mark Hobel for the United States. I think Mr. Lipper and I probably agree that the key element in dispute here respecting the jury's verdict and the sufficiency was the immediate actual possession element. And I do want to turn to that and use most of my time for that. But I also want to just quickly respond to 3 points sort of seriatim that Mr. Lipper made, that there are suggestions that he made or arguments that I think are just incorrect.
I'm not going to interrupt your introduction more than to say I'm also going to have some questions about the jury instruction issue that didn't come up in Mr. Lipper's argument.
And of course.
I'll let you. I know we talked about sufficiency so far, but I'll get to that later.
Okay, thank you. I'm happy to address those, but just the 3 points I quickly wanted to address on the issue of whether stealthiness is required, or it can be a sudden seizure or snatching. Judge Glickman's majority opinion in Bailey very clearly holds that stealthiness is not required. A sudden seizure or snatching is sufficient, and that's what we have here. Number 2, the second point, leak the United States, which is an important precedent from our perspective. We relied on it heavily. Mr. Lipper characterized the second part of the court's discussion in which it postulated whether the defendant and the other person who was wrestling with the victim on the ground while the defendant took the bike, whether or not if they were not Confederates. He suggested that was dicta. It was not dicta. That was in fact squarely the holding, because the issue there was whether a lesser included instruction on theft should have been given, and the court squarely held that even if Leak and the man who pulled the victim off the bike were not working in concert, Leak still robbed the victim by taking the bike off the ground and riding off with it. And then the third point, I think this was sort of earlier in Mr. Lipper's argument, the suggestion that if an object of property is lying on the ground near a victim, that could not be in their immediate actual possession. That suggestion is wrong. Leak, of course, the bicycle was on the ground. Another case, Johnson, which we cite in our brief, a wallet falls from the victim, and even if it was taken off the ground by the robber.
Oh, I didn't understand that to be his argument. If it was, then I totally agree with you. That's wrong. I understood his argument to be more in the vein of, yeah, maybe if you're in an area where you could still reasonably be expected to have control of something, but something like Times Square was his example. I suggested in this protest, being 5 feet away from something is not the same as having it 5 feet away from you in a motel room. Who would expect if I set my wallet where you are and we had 1,000 people in here? Doesn't seem super reasonable to say I have immediate and actual control of it. I've left it to the devices of the crowd.
Right, and so I think that does go to the key issue of immediate actual possession. What variables are at play here in assessing sufficiency? And here I want to focus on 4 kind of key factors or variables that this court has looked at before in assessing immediate actual possession that show that there was sufficient evidence to support this verdict. So the first I want to address is just the sheer distance. I think that the defense has sort of said distance is not really at issue here, because the testimony from PATSCHAK himself was that the body worn camera was 3 to 5 feet from him when he 3 to 5 feet from the officer after it had fallen from the officer when PATSCHAK picked it up. So that's well within the range that this court has found as a matter of pure distance. It can be immediate actual possession. Another factor, and I'll just list before I go into each one, the amount of time that passes, whether there is observation by the victim, and whether there is deterrence by force or violence. So as to time, the amount of time that passes here, PATSCHAK himself testified it was very fast between when the body-worn camera fell from Officer Todd and when he picked it up. He estimated it was about 4 seconds. I would suggest that the court watch. I think maybe the members of the court have already seen Government Exhibit 3, the overhead surveillance camera. I'd suggest it was maybe even a little less than 4 seconds, but the difference is not particularly important there. It was very fast. The third point that I want to highlight is from McKinney, which was a carjacking case, but of course, and this is the observation or the victim's eyes on the property. McKinney and carjacking involves the same immediate actual possession as robbery, but McKinney emphasized that the fact that the victim in McKinney did not have did not have eyes on the car at the time it was taken, that was an important distinction between that case and Sutton, a case in which even though the car was 50 feet away from the victim could see it as it was being taken. That was sufficient to be in the victim's immediate actual possession. Here we had testimony from Officer Todd that he kept constant observation as he was retreating, and he saw PATSCHAK pick the camera up off the ground.
Do we also have testimony on this point here, not to stop you, that Officer Todd was fearful of engaging in the midst of the crowd and as he was retreating, and
Yeah.
that's what prevented him from, how clear, I'm sort of trying to find the exact testimony in the record, but how clear is that testimony from Officer Todd?
Yes, thank you. I think that testimony was very clear, and that goes to sort of the fourth variable I mentioned, which is the setting of force and violence. The leak, the law from the leak case is a bicycle lying 2 feet away from the owner is undoubtedly within the victim's immediate actual possession, at least whereas here the owner is aware of the attempted taking in a setting of force and violence. And this was a setting of force and violence. And the testimony from Officer Todd is that he was retreating for, and I'm just looking at November 8th transcript at 75 through 76 is the key testimony. He was retreating for safety reasons. It was very chaotic, very hectic. The last thing I want is for me to be surrounded by a group of protesters that were there for a specific cause and cause harm to myself. And I can't record exactly what's going on because I no longer have body-worn camera attached to my body. He was asked.
Can I ask you, just a minute, I want to understand how you think that consideration cuts or why or how it's relevant. In a way, you might think that if it's clear to everyone that the person whose object is at issue is deterred from getting it, that might make it less in their immediate actual possession. I mean, if I don't know, if I drop my wallet and it by some freak goes, across a lane of busy traffic and cars are just flying by and it wouldn't be safe for me to retrieve it, and someone over there sees it and opportunistically takes it away, you might think, well, that doesn't, really not so much in immediate actual possession because I'm kind of deterred by safety risks from getting it. So from some perspectives, you could see it as tending to undermine some of the principles that underlie the idea of immediate actual possession. Where it seems like it might be cutting another way is where that deterrence is created by force or other threats by the perpetrator himself or herself. Then I can see it starting to cut the other way. But it seems like can you just let me know what you think about when and how that cuts in which directions?
I certainly agree that with the second, I think I agree with the way that you've described it there, or Judge McLeese, in that I do think that the cases have, and I guess I quote the Rouse case. A thing is in one's immediate actual possession, so long as it is within such range that he could, if not deterred by violence or fear, retain actual physical control over it. So, a situation in which the officer has already been assaulted by PATSCHAK. He's seen other
I don't mean to
yeah.
interrupt, but just on the general topic before you get into this case, that wording about deterred by violence or fear in the hypothetical I gave about I'm afraid to go get it because of traffic and all that, it wouldn't be safe for me to go get it. Do you think there too, it still is in my immediate actual possession and it sort of helps the government in a robbery case that the victim would have been afraid for reasons unrelated to any violence by anybody, but just general fear to retrieve it? You think that helps the government in a typical case, or does it have to be somehow tied more to the conduct of the perpetrator?
The thing that's giving me pause in saying it does have to be tied to the conduct of the perpetrator is the leak case.
I can see why it gives you cause.
Right. But otherwise, as a logical matter, I do have a harder time seeing the situation in which your wallet flies over the highway and you're deterred in that way as akin to a robbery as opposed to a theft. I do, but.
And just to highlight leaks, so here another hypothetical. Imagine that I am being robbed at gunpoint, and I produced my wallet and I've set it down, and the person who's gonna take it is pointing a gun at me and getting ready to take it, and then some opportunistic person comes and grabs it, and I'm deterred from stopping that unrelated person because I'm at gunpoint by the attempted robber who ends up maybe being thwarted. Would you say that's immediate actual possession, even though someone was opportunistically taking advantage of someone else's force?
I mean, I think yes, because that is leak. I mean, I think that is the facts of the leak case, more or less, is that fact pattern. Here, I think you have even more than the leak case, because you have PATSCHAK, who has already assaulted Officer Todd. That's part of what's deterring. His Officer Todd's testimony is, a body worn camera is just a body worn camera. My life is my life. I mean, he doesn't need to risk his physical safety and the safety of his fellow officers to go retrieve that. He can retreat and still be, and it can still be in his actual immediate actual possession. But here you do have PATSCHAK. He's already assaulted Officer Todd. Other protesters, demonstrators, whatever you want to call them, are at this point, it's become very chaotic, have assaulted officers. This is a setting of force and violence. And the other thing that I would say here, and we didn't really bring this out in our briefing, but it is in the government's Exhibit 3, the surveillance video. If you watch that exhibit from about the 20-second mark to the 30-second mark, what I'd suggest to the court you will see is that you will see the body worn camera fly off Officer Todd, go bink, bink, bink. As PATSCHAK is picking it up, you will see a line of protesters kind of get in formation in front of the police officers, including PATSCHAK, blocking the officers from, including Todd, blocking the officers from getting at PATSCHAK. Now, are they doing that to prevent Officer Todd from getting his body worn camera back? Probably not. They're probably just protecting their fellow protester. But that's an extra level of force and violence and deterrence that's preventing Officer Todd from getting his property back. So here, his retreat, and this goes to an exchange, Judge Gillett, you had with Mr. Lipper. In this case, we would suggest that the retreat, there may be other situations where retreat does not weigh in favor of finding immediate actual possession, but in this case, the retreat does weigh in favor because it is in this climate of violence and force and fear. And the officer's testimony was very clear that that's why he was retreating.
Can I just want to have some time to talk about the jury instruction question. I just want to kind of tee up cleanly what my concern about this case is. My concern is that in the government's closing, they float, Mr. PATSCHAK's testimony is, I picked this stuff up in the middle of chaos. I don't even know what this thing is. When I put it in my pocket, later I look at it, I realize what it is, I put it in my backpack. The government's closing a couple of times, I read to say, well, so what? That's still a robbery. I can quote if you need, but the second he pulls it back out of his pocket, looks at it, oh, this thing doesn't belong to me. What does he do? He puts it back in the backpack. Why? Because now this is his trophy. That's the theory. And so now I'm going to direct you to the second jury note, because for the first time they say, I forget the exact question, but they're instructed it needs to be accompanied with the intent to steal something. The second time they say, well, what do you mean the exact time? And what Judge Park says is, I think what they're struggling with is the government's theory of him looking at it out of his backpack about a minute later. This is at page 16 of the transcript. If he just picked it up randomly, didn't know what he was going to do with it, and then later was like, oh, I'm not going to give it back, I'm going to keep this, is the government's theory, would that be an intent to take? And everybody agrees the answer is no, right? I think you'll agree with me that the answer is no, that that's not a robbery. And then the answer to the second note doesn't say, no, that's not a robbery. And it doesn't say, yes, it needs to be at the exact same time. I mean, they could have answered that question with a yes, right? Why not? I mean, I guess I'm just wondering why, as to the second note, the judge didn't do an adequate job of clearing away the apparent confusion that the judge recognized to be what was animating the jury's question.
So I think in this respect, and I want to make sure I'm answering your question, but I think it's useful in context to remember this is an instruction that the defense counsel asked the judge to give. He said, give the original instruction. So this is unpreserved. And Mr. Lipper and PATSCHAK have not made any argument that Judge Park's response to the second note was plainly erroneous, and that's a high standard.
Can I talk about whether it was? I take your point that when you say this isn't preserved, and I think you have a very good argument that it's not preserved, there is some, judge, should we address the timing? This is what I think their concern is. They have an argument. Mr. Lipper has an argument that he kind of got shut down, but not so much. It was he was kind of floated a thought. The judge said, I don't like that. He's like, yeah, I agree, Judge. Well, let's go with the needs to accompany the intent instruction. So, and now I take your other point that they do not, in the reply brief or originally, say it rises to the level of plain error. But as I've just articulated it, put plainness on pause for a moment. I assume you'd agree with, well, I assume you would agree with me that if there's a substantial chance that he got convicted on an invalid theory of robbery, like the one the government floated in closing argument, that would meet prong 4 of plain error, at least to give us the discretion to set it aside. I tend to think where you have a trial judge saying this is what they're struggling with and doesn't answer it, probably meets prong 3 of plain error. Prong 2, I don't know, it's not so plain exactly how to answer that. It's kind of acquiesced to. So where do you think it goes afoul of the plain error analysis if we engaged in it? At what step of the plain error analysis is it going to fail?
The response to the second.
If I put the error in the following way, not clearing away the confusion that if he only noticed he had taken the officer's property a minute later, and then held on to it, that was one of the government's arguments, that would be a robbery. The judge recognizes that as the juror's confusion and doesn't say that wouldn't be a robbery, and doesn't really say something that sounds like that wouldn't be a robbery. If that's, run with me that that's error. Where else do you think it trips up in the plain error analysis?
Even if you assume that it's error and that's plain error, you get to prong 3 and you're talking about where's the substantial prejudice. There is a third note, and the answer to the third note gets it to the temporal aspect that everybody agrees on. It has to be at the time of, and that's. And so there's that it clearly fails at prong 3 because there is a separate, the jury comes back and it says we still need clarification and a proper instruction is given. I'd also say it fails at prong 4, although we don't need to get there because it's largely invited by the defense attorney saying we think that the first instruction, the same instruction, is the safest course, and and he kind of floats and then takes back this other idea, but he goes back to saying we think it's the safest course to give the original instruction. So certainly, even if you were to, I disagree that it's error and that it's plain, but if you just start with the third and fourth prongs of plain error, they're not getting there on the second note.
His response to that, which I don't think is without force, is the jury asks in the second note, do you mean the exact same time? And then they get an answer that doesn't answer that. And then they ask it again, and the judge says, it needs to be at the same time. They're asking, when you say same time, do you mean all part of this same amalgamation of incidents, such that it could have been a minute later? The judge recognizes that to be their struggle. And then he comes back with same time again. I mean, I'm not so sure the jury wouldn't just feel like they're going to get an answer to their question that they kept asking.
Like you talking about the second note or the?
Well, I'm talking about the second note they asked, does it mean the exact same time? And when he doesn't answer that directly, and then the third time he, you know, omits the exact, this is part of Mr. Patchak's argument, then you've left it open to them to interpret it the way they had suggested they might be, which is, do you just mean sort of the whole affair of this protest where he's arrested 45 minutes later?
Right, and there's no requirement that the judge use the exact language that the jury used. It's enough that he clears away their confusion with concrete specificity. Here, everybody, by the third note, everybody agrees the issue is the temporal aspect. It's the time. The unobjected to a response to the third note where the defense attorney says that's good, no objection. The force or violence, whether it's a sudden seizure or snatching or what have you, has to be at the time of the intent to steal. That at the time, you know, as we put it in our brief, I mean, it's hard to posit, and we're on plain error here. It's hard to posit a rational juror that would convict on find that convict on at the time, but would have a problem if the instruction was at the exact or immediate time. It just seems like you're adding I guess that's an extra adjective, but the crux of it, the temporal aspect, is addressed. And of course, it's addressed to the defense's satisfaction because there's certainly no objection to the third note that says this needs to say the exact or the immediate time. Nothing like that. That's really raised for the first time on appeal here. So we would say there's no plain error on the responses to the jury notes, and again, as we've discussed, that the evidence was sufficient to convict on robbery.
Just to clarify one thing, at least at one point, I think when referring to the fourth part of the plain error test, you mentioned the concept of invited error. That concept is sometimes thought of as triggering an even more stringent obstacle or a more daunting obstacle for parties who are seeking reversal on appeal. But I didn't understand your brief to be arguing for anything more than the plain error standard. Is that accurate? Or
that's accurate?
Okay.
That's accurate. Thank you.
Thank you. All right, Mr. Lipper, a couple minutes of rebuttal.
Thank you, Madam Chief Judge. I just want to touch very briefly on the instructional preservation issue at the end. With respect to the third question, and I agree with Judge Deal that the jury was coming back with asking the same exact question for the second time. It was because they still were struggling with what exactly the temporal situation was. And
just to be clear, I don't think they asked the same exact question. Their wording is a little bit different.
Slightly, but
but they're getting at the same topic
getting at the
for
same
sure.
topic,
But
yeah.
it's not the same exact question they asked. The last time they asked, can it be a span of time other than the immediate?
Correct. But it was a sort of another temporal question. The first thing defense, so what they asked is, the second part of the question was, can the entire event be accompaniment? And defense counsel said, we have to direct them towards the right way. The answer to that question is no, right? The trial court rejected that approach. Then the discussion continued to.
And would you agree the answer to the question literally isn't no? Because the question is, can it be A or B?
But I think what trial counsel was saying, the answer to B has to be, you have to say no, B is not correct. And the judge rejected that. At that point, yes, the trial counsel is trying to figure out what the right way forward is. But if, we're talking about in the context of instructions where you're still trying to shape what goes to the jury. Okay, here's what I think the answer should be. The judge isn't going to do that. I still would like to make the answer as useful as possible, akin to, if I am with some friends, we're trying to pick a movie and I say, I'd like to watch The Godfather. And they're all like, no. And then, one person says High Noon and another person says, Gone with the Wind. And I say, well, how about Casablanca? And they say, okay, fine. I have not waived my objection to not watching The Godfather. I just recognized it wasn't happening and tried to, mitigate my losses, so to speak. And I think that's what was happening here. And when the jury was asking something more specific and the judge was answering more generally, the jury might well have said, okay, it doesn't have to be as close in time as our question was positing. Sorry, did you have a? Oh, sorry. Back to the sufficiency. So I want to make a couple points. So Rouse, in which the government was quoting language from, Rouse again involved the victim being held at gunpoint. So again, we have that sort of explicit, threat of violence that we don't have here. Officer Todd's testimony that, my life is more important than my camera is not in itself sufficient, absent sort of an objective, threat to him or objective violence. Otherwise,
But how do you reach that conclusion,
The-
given the setting where there had just been violent scuffle, tussle, whatever you want to call it, between the officer and Mr. Patchak?
I mean, Patchak, at least the jury found Patchak pushed him, and he was convicted of a misdemeanor for that. But we are now at the point where Officer Todd very decisively, neutralized the state. He punched Patchak in the face. He threw Patchak to the ground. He was comfortable walking away from Patchak, with his back turned. And Patchak at the time was just standing there. Patchak was not going back after him, was not pursuing him, was not yelling at him, was not threatening him. And especially, I think the courts to be very wary, given that I think Officer Todd seemed to be hinting at, there was a bunch of protesters who all believe in the same thing. I mean, we do not want to have a standard where, it's robbery at a Black Lives Matter protest, but it would be theft at a Blue Lives Matter protest because all these protesters are on the same side. There, I think, has to be an objective link. Just to give you an example, if I'm gesturing during my argument and my pen pries loose and lands behind the chief judge's chair, under no circumstances am I going to walk over there and retrieve my pen, not because of any threat or violence, but because, I might have to, I guess, the threat of losing my bar card. But under the government's theory, as I understand it, that would be a robbery. And if I later testified, well, I heard that the chief judge takes taekwondo lessons, and and the gavels are really heavy, and my life is more important than my pen. No, but that would still not be sufficient evidence of robbery, notwithstanding my testimony about the subjective fear. And so ultimately, I think, especially when you are talking about the very outer limits of the most marginal theory of what is supposed to be a very serious statute with a maximum sentence of 15 years, the court should not, for the first time, hold that, notwithstanding the property owners walking away from the property in the absence of physical violence or a concrete threat, nonetheless, this would constitute robbery. This would expand the scope of the already broad robbery statute, well past its breaking point. Thank you.
Thank you. We'd like to thank both counsel for your briefs and arguments and the matters taken under advisement. Thank you.
All rise.